Recording in
Good
progress.
afternoon, everybody, and welcome to the Town of Greenwich Planning and Zoning Commission meeting being held virtually. Today is Tuesday, December 17th. And I don't think we're going to need our alternates, but the seated alternate would be Ms. Jones. This afternoon, we have 3 postponements on our agenda that would have been decisions items. These are Greenwich American Inc. for a zoning text amendment, the same applicant for a zoning map amendment which would affect One American Lane. And I'm sorry, they're not 3. Oh yes, and the third one is the final site plan and special permit, again at One American Lane for Greenwich American Inc. And with that, wait, did I just see we got an email with materials just now? Patrick? Okay, it's, well, then that they're from Mr. Hegney?
Unbelievable.
Okay, so when he comes in, he's gonna have to explain it, explain whatever he's just sent us. We'll try to look at it, but I don't see how.
Wait, whoa. We just got this? No,
Yeah.
no
I just have
explanation.
the-
I just got this. 4:02,
Okay.
meeting's open, right? We started already. Too late.
So we have an email that just came in from Mr. Hegney. Let me open the application first. Mr. Hegney in, because he always likes me to announce it after he's in. Mr. Hegney, if you would raise your hand. All righty. All righty. And Mr. Hegney, will you have your co-counsel also with you?
Yes, please, if you could bring in Tim Hollister, Madam Chair.
Okay. All right. So our first and only item on the public hearing tonight will be Mason Street Partners LLC for a final site plan and special permit to develop properties on both the east and west side of Mason Street. What is proposed is a mixed-use commercial and assisted housing development per Section 830G of the Connecticut State Statutes. This is for 75 residential units, where 24 units, 12 in each building, would be below market and deed restricted. The addresses for this application are 405 Greenwich Avenue, 290 to 294 Mason Street, 275 to 289, and 309 to 321 Mason Street. Mr. Hegney, we have an email that you sent at 3:53 this afternoon, which reached us at 4:02. So we have not seen the contents of your last minute material.
Quite all right, Madam Chair. It's one item that we wanted to include as part of the record, but it will not be a significant part of our discussion this afternoon.
Well, if it's part of the record, it's not exactly appropriate for the commission not to be familiar with it and not to discuss it. If you are planning on putting it into our public record, we need to know what's going into it. So we are going to have to cover what you've put into this.
That's fine. We can discuss
if you're going to be teaching us the law, I believe that would be an appropriate addition. Thank you.
Well, anything
Okay,
getting
so
added to the record
is the commission should see prior to reaching a decision. So, thank you. Okay, Mr. Hegney, with that, shall we proceed?
Yes, thank you, Madam Chair, members of the commission. For the record, Tom Hegney on behalf of the applicant. We've been at this actually a little over a year now. I noticed our pre-app was in December of last year when we first brought the project to you. You had a decision in September that denied the application that was for 92 units with 30% as affordable. We have since filed what is now before you as a resubmission under 8-30G. And we've addressed, I believe, all of the issues that were brought up as part of the denial. And I just want to go through and list those items that we have provided that the commission had asked us to address in its decision letter. Provide a copy of the phase 1 environmental assessment that was submitted. Provide the property transfer 3 forms, which were filed with the Department of Energy and Environmental Protection. We submitted those to you. We submitted revised plans that addressed the Public Works Traffic Division, and you have a memo from that department indicating that any minor revisions can be submitted prior to building permit. We submitted revised plans and a drainage report, which addressed the issues of the Public Works Engineering Division. Again, where you have a memo from them saying that any other items can be addressed prior to building permit. We addressed the fire marshal's comments regarding access and an emergency generator for the 6-story building. We provided a revised affordability plan addressing the housing specialist comments. I know there were a couple of other minor comments that were made, but those are those are items that we can address prior to zoning permit sign off. We submitted a lighting plan that showed just either down lighting or for egress purposes at doorways. We provided an updated construction phasing and logistics plan to address how the buildings would be constructed. The units now, the affordable units that is, are dispersed between the 2 buildings. That was one of the main concerns that was expressed by the commission at the denial of the prior application, and also that all of the amenities are available to all of the unit owners. So it's not just certain unit owners that would be that could avail themselves of the amenities. It would be all of the units can access it. And the commission did obtain the services of third-party peer review, Fuss and O'Neill, to review what Langen Engineering had done as part of the addressing the environmental cleanup issues that are there. And Fuss and O'Neill agreed with Langen's statements that the report and conditions that Langen has indicated are appropriate to allow us for a successful redevelopment project that results in an outcome that is protective of human health under residential reuse scenario. That was from Fuss and O'Neill's report. The items that came up as part of the discussion yesterday at the briefing involved the one use of retail as part of this.
Okay, Mr. Hegney,
the-
just a second. You know that the retail and the commercial use was in our original decision. You're aware of that.
Yes,
You're aware that that language, okay, so
yes.
that remains an open item for the commission, just checking.
That-
And I just, as long as I
if I
interrupted
didn't
you, yes, you didn't say it. Yes, you did not include it.
move it to the
And
next topic
yes,
smoothly
Mr.
enough,
Hegney,
I apologize.
you did not include that in your listing. And then the second
No.
thing is, the reason that the commission raised the issue in broad terms about the separation of the affordability between the buildings and what in New York was called the rich door, poor door because of that lawsuit in New York State was because it affirming and moving forward of affordable housing means considering equity and real inclusion. And so that is not, I believe Mr. Caspi at one point said we were raising new topics, but in general terms, we continue to raise this issue of equity, of inclusion, of comparability. And that's the same reason we questioned you on the location in between the 2 buildings of the affordable and the not. So if you would just continue, again, these items were in our previous decisions, so it is not that we have raised new topics. Anyway, please continue.
So our first project that we submitted to you had all of the affordable units in one building. And the commission raised this issue at that time as to whether it was appropriate to have all the affordable units in one building and all of the market units in another. And we had a couple of iterations after that. We had one unit in the condo sale building and 3 affordable units and 3 market units rather in the rental building. That was not seen as being acceptable. We then had 3 affordable units in the market building, and that was part of the plan that was denied by the commission in September. Of course, the plan we have now has 24 or 32% of the units as affordable, and they are split equally between the 2 buildings. And they are on different floors within the building and different locations within the building. So we believe that we have addressed that particular issue, and we're prepared to have further discussion on that as well. And Tim Hollister is going to go over that with you. What I was going to do at this point is go over the retail part of it, because what we have now currently on site is on the west side, 15,360 square feet of retail use. And we're reducing that to 3,999. And that was, again, to address the commission's concern about the total square footage of retail on that property. The plans that we submitted showing the setbacks along Mason Street, showing that 3 feet is the average for the setback off of Mason Street for the retail use. We believe that we have met the setback for the retail use for that west side. Likewise, on the east side, there's 8,815 square feet of retail, and we're proposing 7,025, actually 16,000 because it's a much larger parcel. 16,165 square feet would be permitted. We're proposing less than half that. The retail portion of the building meets the CGB setbacks in the zone, including to the east, where it's the R6 zone and residential.
And again, Mr.
building
Hegney, just to go back to the previous discussion that we had on this topic, you believe that zoning setbacks apply to uses and not to structures. Is that correct? Is that what that is your claim?
Because this is an affordable housing project.
Oh, and
it
wait,
is,
so because this is an affordable housing project, you're thinking that the setback should apply to a use?
No, I think that as an affordable housing project, there are no setbacks that apply under the zoning regulations. And what we're showing you is the retail portion of the building, which is 4.4% of the total of 248,000 square feet, does meet that setback.
I'm sorry,
This
so
is,
again, you're saying that the use meets a setback as opposed to the structure?
yes, and I would submit to you that looking at it as a retail project with a housing component is not the way that this plan is being prepared or submitted. It is a housing project with a retail component, and that retail component is helpful in terms of assuring the ability to provide the 24 affordable units, and it provides the retail continuity that the town is looking for in this part of the avenue and Mason Street. So we think that this is valuable, and that requiring the entire building as a to meet the CGB setback doesn't recognize that this is an affordable housing project. If I came in and had 1,000 square feet or even 100 square feet of retail space, taking the commission's position to its absurd conclusion
Excuse
then
me?
I would
Wait.
still need to,
Excuse me, we're not going to go there, okay? Nothing about our
do you mean?
conclusions being absurd. Our conclusions aren't absurd.
no, I'm saying
I
that
mean,
if
Mr.
we
Hegney, this
took
is
it
not a way to
to that
start a
conclusion,
conversation that should be productive and working together. You continue to use this kind of language, both of you. Again, what we have argued and what we're saying is, number one, 830G is silent as to commercial uses. Number two, if I could use a somewhat crude example, the fact that pregnancy is omitted from the statute does not mean that it's okay to be a little bit pregnant. It doesn't say that in the statute. Well, we're not going to mention pregnant, so a little bit pregnant is okay. Number two, number three, I lost count, is we're not, you're putting this forward of the setback from the use. There is no precedent about use setbacks in this kind of a situation, nor is there a mandate that I know of that we should enable the commercial for the applicant for any given reason. None of this is in the state statute, nor has it really turned up in case law. I don't know why you're making that argument.
because it doesn't, the statute doesn't prohibit it, for one.
No, but it doesn't say it's okay. We're not mentioning
And
it. So pregnancy
the,
is not in, and a little
the
bit pregnant is your interpretation of okay. I'm sorry, I can't think of any other
and
example. You guys, the lawyers are going to tell me I'm
and
too colorful, but there you go.
it's quite all right, Madam Chair.
Oh, as
The
long, and what was the other thing? And we're also absurd. Go ahead, Mr. Hegney.
I said the example is that if I had 100 square feet of retail, that would require the entire 248,000 square foot building to still meet the CGB setback, even though it's all residential. And I would submit to you that that doesn't make sense.
No, what we're submitting to you is that the statute is silent as to commercial uses, which means that they don't have to be there. Mr. McRae, would you like
And
to add something?
there, if I could
Yeah,
just
okay. Would you like to
make another
finish? I'm
point,
sorry.
Madam Chair. Thank you.
Yes, sir.
It the cases that have dealt with the commercial use as part of a 8-30G application have really gotten to the point where they say you can't have a commercial
bootstrap.
building with a little bit of residential. That's not the case here. We have a significantly large affordable housing project right downtown with a small component, 4.4% of it being retail. We think that that's an important part of it for two reasons. We want to have continuity within the retail district. And secondly, it provides additional funds to be able to support the development of very significant and large affordable housing units. And so it provides a real benefit to its location and to the project itself, while being a very small component overall of the building.
And if I might also clarify, we have never in this application discussion prioritized retail continuity to you. This is a concept that you have introduced into this, but this specific site has been of a different ilk. Are you okay with the commissioners other than me speaking now?
Of course, Madam Chair.
Mr. McRae.
Mr. Hegney, is the retail portion, does it share the exterior wall at the first floor with the rest of the building?
It does on the Bruce Park Avenue side and on the southeast portion of Mason Street.
Mr. Hegney, normally in any other kind of a site plan or application, municipal application, in my experience, you take actually the setback dimensions from the property line to the exterior wall of the structure, foundation, so on and so forth. And in this case, applying that same reasoning, isn't the foundation or the exterior wall of the building, it's the same wall that supports the retail up above. Is that correct?
I'm not sure I follow you, Mr.
Okay, so
McElroy.
you're as Ms. Alvin was saying, you're dimensioning setbacks to an interior wall, to a use, not to the exterior wall, which to me, in my experience, seems to be contrary to the way that everybody else in the world, or in this country, in this state, in this town, measures a setback to a property line.
Right.
Now, I would actually expand on this in an abstract to say, wait a minute, if I'm going to take this idea that's being proposed now and say, wait a minute, I'm actually going to say I have crawl space, but I only have a full foundation in the middle of a house. So I'm going to take the setback to the crawl space because the rest of it's uninhabitable. I don't believe that would fly anywhere. And I find that actually this argument that I'm taking the dimensional information to the interior walls or the use of a retail space, but not to the exterior walls, is a little odd. Lack of a better word for that. And I think this gets back to that word we were talking about, absurd. Yes, this is absurd.
Yeah, but
You have a
it was us
foundation that holds
were
up a
absurd.
building. You have a mixed use here. You have retail. You're saying, oh, the retail fits because it's if I measure it to the property line from this interior wall, it works fine. But we've already established the fact that actually it shares walls with the rest of the building itself. So I think the idea of actually saying, oh, we can take this dimension to this interior wall really doesn't fly. And I think actually it's that issue, although it says, in case law and here and there, what it does. I think looking at it here, at face value, the fact that actually this building does not meet the setbacks because of this convoluted idea that you're actually measuring to an interior wall, not an exterior wall.
A use, not even an interior wall, Nick, a use.
Give you a use.
Mr. Lowe?
Yes, in your, I guess I'm speaking to both attorneys here, your collective memorandum dated yesterday, I believe, you state that the retail use is permitted because it is accessory to the primary residential use, while at the same time, and actually the same sentence or paragraph, acknowledging that the proposed, quote, the proposed, retail use does not strictly comply with commercial business zone setback requirements. Is there anything in the 830G statute that addresses the issue of the accessory nature of a non-residential use?
We cite a couple of things, Mr. Lowe. One is that it's interesting that our regulations don't have a definition of accessory. The only place I find a reference to it is in 6-196, which talks about accessory buildings that need to be subordinate in size to the primary building as part of granting a special exception.
Okay.
I thought that was a good analogy.
That's not the question you're being asked, Mr.
That's
Hegney.
not, you cite several cases involving the relationship between commercial, primary, and accessory uses. Do any of these cases include 830Gs?
No.
If not, what relevance do they have to the 830G affordable housing statute?
Mr. Lowe, this is Tim Hollister, I can answer that. The cases that are in the memo that Mr. Hegney and I prepared and sent to you yesterday are not 830G cases, which I think only underscores our point. These are regular zoning cases. This is regular zoning law, not related to or based upon 830G. If you have a retail use that is so small and subordinate that it is accessory to a residential use, then you use the residential setbacks, which in this case under 830G are essentially does the setback create a health and safety issue that the commission could use to deny?
Mr. Hollister, excuse me, do you agree with Judge Berger in that 65 Marsh Hill Road case that, and I quote, the legislative history indicates that the legislature intended to accomplish the goal of encouraging and facilitating affordable housing throughout the state by creating specific legislation that affects only affordable housing applications, not the overall zoning scheme. and his conclusion that applications that do not fit into the definition of an affordable housing application are not affected by 830G. Do you agree with that?
Well, if you read from the decision, I think I have to agree with it. Here's the sort of the macro problem here, Commissioner Lowe.
I'm sorry, I'm dealing with a micro issue here. This is where I'm trying to sweep out kind of a macro worldview of this thing. We have to deal with the application in front of us.
Yes, and my macro issue is you're dealing with this improperly as a micro issue. If I could finish my answer, please.
Sure.
The 65 Marshall Road talks about, which involved a 23,000 square foot commercial use on a 3-acre property. And Judge Berger said quite rightly that was the tail wagging the dog. That was not an appropriate use of 830G. He did not say, in my opinion, that retail uses are forever prohibited in anything involving 830G. Now, the difference, frankly, between the way I'm approaching this, based on 34 years of experience with the statute and 200 applications, is to look and say, Judge Berger, in that case, ruled on a specific set of facts. He did not announce a rule for all 830Gs. Respectfully, the commission, or at least you in your comment, are taking the sentence and making it a rule for all 830Gs,
No,
which I don't
not at
believe
all.
is.
Not at all, Mr.
No,
Not at all,
I'm making
Mr.
it- I don't
Hollister.
know
Well,
about
you're putting words in our
830Gs.
mouth. We've
Yeah,
approved
I'm
830Gs.
expressing.
No, I'm sorry, Mr. Hollister.
No,
We've
I'm
approved
talking
830Gs with,
about this 830G.
Yeah.
I'm not talking about all 830Gs.
And respectfully, you are incorrect, in my opinion.
okay, and Mr. Hollister, for the record, we have approved an 830G with commercial quite fairly recently. When did we approve that? Hamilton Avenue. We're not making it for all 830Gs. We're just telling you that
But-
our read is you don't have the right under 830G to override the zoning as applies to commercial uses. Full stop. You
No,
don't get to
Yeah, excuse me.
override.
Just
And
for the
by the
record,
way,
No,
yes,
just
go
for the
ahead.
record, you just said I was incorrect. I asked you a question. I didn't make a statement. So am I incorrect in asking the question?
Well-
And I have another question for you, but that's what it
Okay.
was. It was a question. Do you believe that a proposal to create affordable housing under the 830G statute does not allow a general zoning override when non-residential uses are included?
Does not allow,
Enables,
830G,
take out all the negatives.
Yeah.
Does
I think
830G enable a zoning override of non-residential uses?
yes,
Oh, really? Where does it say that
All
you
right.
can override non-residential uses?
if in exactly the situation that we're dealing with here, where you are
It
the.
does not
the
say
ret-
that, Mr. Hollister.
Well, Madam Chair, respectfully.
It's silent. The law is completely silent on commercial uses.
And I'm telling you that the case law, including
Well, he didn't
Marshall
ask
Road.
you that. He asked you 830G. He
Well,
said,
830G to
does
me is a
830
combination.
no, he asked you, does the statute 830G enable the override of commercial uses, zoning for commercial uses? And the answer is no. The 830G statute does not. That is what we're discussing. And by the way, Mr. Hegney, while I have the floor, we do have a definition of accessory in our regulations. I don't know why you think we don't. Not that I
looked-
believe you're
I-
accessory. Try taking a look at 65A6. But I don't believe that this accessory argument is
I don't
relevant.
think it's relevant.
And I'm sorry, Mr.
Or I'd
Hollister,
like to
we
be
will
just abusive.
let you,
How is it relevant?
go ahead. I'm going to let you and Mr. Lowe talk and we won't interrupt. I apologize.
Well, I was just going to say, when you say does 830G, there's the statute and then there's the case law that has evolved over 34 years. You can't talk about one without the other. You can't say that the word retail does not appear in 830G, end of story. That is not how a lawyer would analyze the question. It is not how I have analyzed the question. The analysis that we gave you in yesterday's memo centers on the first fact that this, under regular zoning law, this is an accessory use, and the commission cannot use retail use setbacks to defeat even a regular residential use, not even one under 830G. But the fact that it is 830G compounds the analysis in our favor, in the sense that the retail setbacks that you are requiring, the building dimensional setbacks you are requiring, are not conceivably public health or safety issues. So that with those two factors, as described in our memo, we believe we are in the right, and we believe the court would uphold our position.
So
Well,
once
what is
again,
when you say regular, what is regular about 830G?
No. Regular meaning non-830G.
Well, but you're using one to support the other, am I right?
I'm saying that Mr. Hegney and I have been doing this in the alternative under the regular non-830G zoning situation, where you have an accessory use and that's defined. Remember, we had a conversation, I believe it was in November, about whether accessory can be defined by the percentage. And I've given you case law both from Connecticut and other places that show you it is defined by a percentage, and 4.4% shows that it's accessory. And when the retail is accessory, what dimensions and setbacks do you use? You use it for the principal use, which in this case is the residential building. That's the simple point we're trying to get across. Now, if you disagree with that because the word retail does not
the
appear in
case law,
830G,
Don't we need to think of this not in terms of regular, but in terms of an 830G application? It's different from a regular application, is it not?
No, what I'm saying is that in the analysis of the application before you, you could approve the proposed retail use even if this weren't an 830G, but because it's an 830G, you have another reason to approve it.
We could approve the.
I'm trying to find a reason that I'm trying to see where it is, and
we try to give it to you with precision, with case law that you asked for in yesterday's memo. I'm not sure I can improve on that.
All right, Lo, have you made your points, do you think, or do you want to keep going?
No, I've asked my questions. Thank you.
And you did not get answers from what I could tell. Mr. Mac.
Madam Chair, that was not necessary.
You answered him. Okay, so then let me just step in. The case law on 830G, as we have all been reading it, I've been rereading all this stuff that I could find from my book. It applies to the concept of bootstrapping. And what you're saying is, since it doesn't enable the bootstrap, therefore it enables an accessory and minimal use. So you're saying, okay, so the inverse is allowed because you can't bootstrap. That is a very large leap that you're taking, and I just don't see it. I'm going to go to Mr. McRae.
Mr. Hegney, the term accessory use, are you using that as a complementary accessory use to the residential above, or just a plain accessory use to the total project?
I think it fits with both, Mr. McRae. It is accessory because it has a retail component as part of the residential development. I think it works well.
So Nick, where you're going with this?
So actually, where I'm going is, so as an accessory use, if I go to rent that accessory or that retail space, and I sell caskets, it's an accessory use because it's retail, but it's not complementary to the residential above. I guess that's a plain statement. The other issue is that if I'm understanding this argument, that the commercial is so small almost to be inconsequential. If that's the case, would it be possible to do without it completely? Because I think actually it seems to me, comparing the rest of the building above it and the site that it sits on, it's such a minor thing. Is it really needed?
The short answer to your question is yes. When we submitted our figures to the Affordable Housing Trust Fund Board, we included that because it is important to add that income and revenue to the ability to have this as an affordable housing project where you're providing units at a very, very low discount from what the market rate units would sell for. So yes, and they have similar cost of construction. So yes, it is an important part of the project.
Okay, so if you didn't have the retail, the whole thing would come tumbling down.
And to that, Mr. McRae, I would remind you and Mr. Hagney that we approved, I don't remember, what would you say that's less than what's that, like a quarter mile away? We have a project that we approved for an 830G, 120 units with 40% affordable housing, 40% below market, 120 units, and it has no retail. And, the commission looks at that set of facts and says this building worked. It should therefore be plausible that yours does. Mr. Wells?
Thank you, Madam Chair. I had a couple of questions basically on basic math. Looking at your memo dated December 16th, applicant's final supplement. And on page 5, we've been using averages in our analysis in terms of, comparability of size.
And that, by the way, is in all those, that's in the record, right, Patrick, what you shared with us yesterday and have corrected since?
Yes.
Okay.
Thank you. And I guess
Madam Chair, if I may, Mr. Wells.
Mr. Wells is speaking.
Yes, I'm going to get to comparability. You're getting ahead of our presentation. I just caution you on that.
I think we're kind of done. I mean, unless you've got more points to add, what
Oh,
else
I've-
do you want to,
Oh,
what else
I
do you
have
want to
several-
say about you're arguing that you're taking Berger's, not allowing the bootstrap and going to the inverse. Do you want to add to that? I think where we hit last time was we're just not seeing the case law or 830.
Oh,
Well,
Thirty
the way-
days, the way
Madam,
you
Madam
choose.
Chair, if I could, there were two main issues that were part of the discussion yesterday at the briefing.
Yes.
One was the setbacks on retail and the appropriateness of the retail. That I think we have had a full discussion on, and we understand
Bingo.
your position. I hope you understand ours. So the second was on comparability.
Which
And
is where
that's
Mr.
what-
Wells was going.
And that's what Attorney Hollister is going to present to you, in addition to the material that we presented
So that's about what
to you
Mr.
yesterday.
So what Mr. Wells was at, where he was headed, Mr. Hollister, since I kind of know him a little bit, is it seemed to me he was going to talk to you about the math of the numbers that you have submitted. Is that correct? And that he wanted to not discuss any legal points, but he wanted to point out something in the math. Is that right, Mr. Wells?
Yeah, that's
Or am
what
I
I was
putting-
thinking. Just clarification, really.
Yeah.
Well, if I'm allowed to proceed without, and I guess my first question, so we've been using averages, average square foot to compare 2-bedroom, 3-bedroom, and Pat's done the analysis. But you all are using median, and can you explain why are you using median as opposed to averages? Is there something in this data set that's skewing it to having you lean towards medians?
Yes, Mr. Wells, Commissioner Wells. First, and not to be glib, but people don't live in average size units. In this case, as you know, media is the spread of numbers can skew the median. When we talk about housing on the financial side and also on the square footage side of units, generally median is used because median, you can talk about the median point and then the range, and I think that gives you a more accurate picture than a straightforward average. I believe it was you yesterday who pointed out quite appropriately that there's an issue with analyzing the numbers in this case with what you called outliers, numbers that for whatever reason are just very large unit sizes. And I think by using a median, I'm trying to mitigate, if you will, the impact of the outliers on the analysis. That's why we did it that way.
Okay.
I'm not sure that people live in median-sized units either. I'm not sure that was a very
No.
illustrative, but go ahead, Mr. Wells.
I guess the second question is just using your medians for the 2-bedroom, the median ratio between, affordable and marketable is 71%. And for the 3-bedroom, it's 51%. So you have a big drop from the 2-bedroom to the 3-bedroom. And then when we do averages, we're also seeing at least in your east building, we're seeing the same drop. For 2 bedrooms, it's 90% on average size 90%, 2-bedroom affordable to 2-bedroom market. And then on the 3-bedroom, the average is 64%, 3-bedroom affordable to 3-bedroom marketable. But a 20% drop is pretty large. So even using median, you're saying the affordable units are only 51% using the medians of the marketable. And you make an argument that it's okay, but I don't understand the argument. Could you please go into that a little more?
Okay, well, again, if you'll indulge me, this is why I was hoping, I have a whole presentation on comparability, including unit size, that leads into the exact question you're asking. My answer will be much more understandable if I can present it to you in context. Now, if you demand that I go off script and address this now, I will just say that the 51% includes the biggest units, and that is not a correct and accurate way to judge the comparability of the unit sizes, because it's the largest units that provide the financial subsidy. The units that are more than, say, between 2,500 square feet and almost 3,900 square feet. Those are in there because it's a for sale building that's allowed, that spread is allowed in a for sale building. So we should not be looking at the largest units and averaging those in. I'll get to that argument in my presentation if I am allowed to get there.
Okay, but I have a follow-up question on that.
Yes,
the
sir.
reason you use median is if you have a skewed distribution, but you just made the argument that the affordable is so much lower because they're larger
Right.
market units. But when you take the midpoint, you get rid of it. It's just the midpoint they're the same numbers above the midpoint as they are below. So
Okay.
these larger numbers on the top side don't make a whole lot of difference.
Okay. Well, if you had it, this is what I was going to get to. If you look at the Exhibit A in the memo that we sent you yesterday, the argument that we're making is that there is both in the 2-bedroom and 3-bedroom affordables and
Have you corrected those numbers now? Because apparently there were errors in them.
3-bedroom unit that was on the wrong line. We actually had 76 units on the
We had
original
more.
table.
We had more
All right.
units.
I mean,
Yeah, so we
it's
fixed that. There
hard
was
when
a-
you keep sending us data
Well-
that is, because it doesn't lead to a positive response, but go ahead. So
Well, it was one
go
line
ahead to
and
your
one number.
illustration. Yeah,
Okay.
go ahead.
So if you look at let me put it this way. Start on the left column where it says 2-bedroom affordables and 2-bedroom market rates. First 15 units are 2-bedroom affordables with a size range of 1,250 to 1,437. The median, as I calculated, is approximately 1,343. Then below that, you have 20 of 27, not the whole thing, but I'm trying to parcel this out in a reasonable. If you go from 1,599 all the way down to 2,170, those are in a range that is where the ratio of medians between the affordables above and the 20 units below is to 71%. So what I'm doing, and quite purposefully and intentionally, is I'm eliminating the outliers. You see the jump from 2,170 to 2,347 and then going up to more than almost 3,200 square feet. So I'm justifying it in that way. Then if you go over to the 3-bedroom column, you have the first 9 units in a very tight range, 1,527 to 1,649. And then you have the next 9. And again, I'm trying to create a comparable field from 1,667, although even that one unit is an outlier. So it's basically 2,301 to 2,479. That is a 76% ratio. So what we're trying to show you with these numbers is this is not, the ratios of comparability are not just based on one or two units. They are based on substantial portions of the building, and they are in the comparable range. So what I've done on that 3-bedroom side is I've, as called, again, using your suggestion, Commissioner Wells, is to take the 2530 to 3899 as outliers, which are allowed to be in the building because this is a for sale building, but are not fairly used to pump up the square footage of the affordable units or the smaller units in the building. So that's what I was going to get to
where did-
in context.
Can I
Where
ask?
where did you get this language about what's allowed to be in a for sale building? This is unfamiliar to me.
No, it's the concept we've already introduced, is there is a
Oh, okay,
fundamental.
so you're saying it's allowed, but it's not in a statute or anything like that?
That's correct, Madam Chair. It's not in a statute.
A quick
Okay.
question on, you mentioned a number. You said the median for the 2-bedroom affordable. You gave us a number of 13 something.
1343, I believe.
Why isn't
I
it
did.
1289? If you have 15 units, why isn't that 8th unit the median?
Oh, well, okay, you could do it that way. It doesn't really change the result by
Well, no,
more than-
how else do you determine a median?
Well, what I did was I took the top and the bottom and I took the midpoint and made that in other words, the difference between 1250 and 437 is 187. I took half of that and added that to the 1250 to get.
That is not the median.
That's not the
definitely
median.
It's one-
median.
it's one-
That does
it's one-
not, that does not
That does
follow
not
the
define median.
definition of a median, as
That's an
Mr.
arbitrary
Lowe is pointing
exercise.
out. That's mumbo
Oh,
jumbo.
Okay,
Give-
let's use
use-
1289.
use-
It's the,
If you're
it's the
going to
same
use
result.
the term median, put an asterisk next to it and say, this is how we're using median because we think it makes more sense. Use that. We can't deal with this. Median means nothing. You're not
can't-
using the mathematical term for median, which is what Mr. Lowe pointed out. It means the same numbers in the data set are above the median as below, and you're not doing that. So I can't rely on your numbers, and I can't
Well,
figure it out.
I believe I'm using one appropriate way to.
No,
arrive at a median.
There's
No,
one
it's not.
definition
It's
for
not a
There's
median.
only
median. Call
one-
it something
Okay.
else. Call it Hollister's number. Don't call it a median because it's not a
Right.
median.
Okay, but you have the
It's
median is
not an
sitting there.
appropriate way, sir. It's just like we've all taken statistics courses, both in our
So
I'm guessing that both in our undergraduate and graduate coursework, we've all been required to take them. Perhaps attorneys don't take stats, but the bottom line is there's only one way to calculate a median, and it's exactly what Mr. Wells just said. The number above and the number below have to be equal. You can't just say n'importe quoi. I'm sorry, in English. You can't.
Madam
Mr.
Chair,
Yeski, Mr.
I-
Yeski, I'm going to stop because I know you have your hand up. Unmute, please, sir.
I'd like to back up a little bit.
Thank you.
Even if you look at the math, are you telling us that at 71%,
There you go.
this is comparable? Is that your argument? I'd
one
like
of
to
the-
get to the
it's-
substance
it's-
of it.
It's one of the factors, yes.
No, but that is the factor.
No, you can't use just the number to establish comparability. That's part of our argument. Comparability depends on many different factors, which I'm also prepared to go through in my presentation.
Okay, so
And
one
we have done-
is size. What are the other factors according to your calculations?
Comparability here is established by the fact that the units are restricted in perpetuity by Schedule B of the Affordability Plan, which creates the schedule of minimum quality finishes and amenities.
Well, are the market
Distribute-
units restricted in forever for sale? I mean, are they also equally restricted?
The price of the market rate units is not restricted.
So what
Okay,
his point, Mr. Yeski, is saying to you is comparability means two things are very similar or the same. And so
Well,
when you
y-
say comparability is given by the restriction, the deed restriction, what Mr. Yeski's saying to you, it has to be apples and apples, and there is no deed restriction for the market units, so that's not a factor in comparability.
Okay, I'd
Well,
like
I
to hear
dis-
the other, I'd like to hear all the factors because we can
Go
keep
ahead.
arguing about every one, but all
Well-
right, what's the third one?
The distribution of units through the building, equal access to amenities, And we'd like to point out that the minimum floor sizes of the affordable units, Mr. Caspi and I, Mr. Hegney have had long discussions about this, will be approximately at the top of the market in Greenwich for condominium units. These are not small units in the overall market. And I believe the exhibit that Mr. Hegney was trying to be introduced at the beginning is further evidence of that. These are very large units. Even the smallest unit in these buildings is one of at the top of the market in terms of size of a condominium unit. That's another factor. Now, Madam Chair, I want to go back. I took statistics in college.
Good for you.
I believe that I have given you an alternative way to arrive at a median when there are variable data points. That, I just want to put that on the record. I didn't make this up. And I rest on the fact that if you want to use
I'll let
Mr.
check
Wells's terminology, you have the data right in front of you, and the difference between the median doing done one way versus the way I did it is inconsequential.
So
All
are you
right, now
applying
let's-
median to such things as amenities as well? Is that what you're saying?
No, the median is a floor size. The Schedule B is the list of minimum amenities, minimum quality, construction quality materials, finishes, appliances, things like that.
Right. I was just trying to
Which-
understand, you've said you seem to be saying that median embraces things other than just that midpoint.
Yeah, AI
Yes,
is not
yes,
finding
yes,
that, Mr. Hollister, your alternate calculation didn't show up in my AI search, but I'll tell you what, I'm going to let Mr. Wells talk, and then we're going to try really hard to let you finish your presentation, okay? Because I know you want to make it, and we should allow you to set the record. So Mr. Wells is going to ask you a question, and then we're going to stand down and try to let you finish. Mr. Wells, go ahead.
I'm just kidding. The only numbers I can rely on are what I got from Pat. So unless we want to calculate what median really is, but it isn't what it appears to be. So at this point, I'm relying on Pat's numbers. Thank you.
All right, Mr. Hollister, let's give a shot at you giving your presentation.
Okay, I have two topics to cover, one before I get to comparability, and this is the first one is the letter that I sent to Mr. LaRoe, which he said he received and distributed to you in the vicinity of 2:30 p.m. this afternoon. This is an important procedural matter. I will apologize in advance for being the fly in the ointment, but earlier today, Attorney Hegney apprised me that the Greenwich Charter and Ordinances, Section 85 little a in parens 5 requires 4 affirmative votes from 5 regular members, a so-called supermajority vote, to pass what the charter calls a quote affirmative vote unquote, which in here would apply to the site plan approval. In my opinion, that voting requirement violates Connecticut law, which requires only a simple majority of a quorum to adopt a site plan. Attached to the letter that I emailed to Mr. LaRoe today is a 2021 Superior Court case from Middletown involving a zone change that invalidated a supermajority voting requirement that essentially mirrors Greenwich's position. Now, again, that case involved a zone change, but if you read especially pages 6, 7, and 8, the reasoning of the Superior Court judge applies equally in the site plan context. So I prepared a letter explaining this, including the Middletown case, and that is attached to the letter. In addition, the second argument is that a supermajority requirement is also inconsistent with 830G, which is a remedial statute. So if the commission uses a supermajority for affirmative voting standard in this application, and the application is not approved because of that 4-vote requirement, we believe that would violate 830G. In 2018, Judge Berger invalidated in a similar context a protest petition that was filed to force a supermajority vote against an 830G application. In that case, called Housing Authority of Brantford versus Branford Planning and Zoning Commission is also attached. So I submit that your voting standard on this application is a simple majority of a quorum. I'm raising it now because as part of our obligation as applicant is if there's a procedural issue to make sure that it's raised on the record during the hearing. So I'm just doing that as a matter of due diligence. Okay, let me turn to comparability.
Mr. Yeski, did you want to ask? a
No, I think
question?
he said it, and I was going to bring up the same point. We get it. It's a little
Okay.
early, but he wanted to get it on the record. I got it.
All right. Okay. Thank you, Mr. Yeski. Go ahead, Mr. Hollister.
Thank you. Let me start with the financial aspect of the comparability issue, which we've been so focused on size. This has kind of gotten lost in the discussion, I think. In affordable housing in general, the market rate units provide the financial subsidy that allows the applicant to provide affordable units at below, sometimes well below market rates. This is inherent, for example, in the 30% minimum ratio of affordable to market rate that is specified in 830G for a set-aside development. In this redevelopment, the revenue from the retail space, that, as Mr. Hagney mentioned, and the sale from the prices of the 51 market rate units, especially the largest units, what we were referring to a little bit ago as the outliers, though that is the revenue that will allow the applicant to sell 24 affordable units at discounts to market price that my client has estimated at more than $2 million per unit. That's a $48 million subsidy at the minimum, and it's the revenue from the retail and the market rate units that allows the applicant to provide that discount in the market. As a result, and this is the point for you with the commission with regard to comparability, in making demands for smaller market rate units and larger affordable units, or insisting on total dimensional compliance for the retail space, the commission needs to understand you are intervening directly in the financial plan, the financial model for the redevelopment in general and the affordable unit subsidy in particular. And there is a point at which you will threaten, if not undermine, the affordable unit plan as a financial matter. And as Mr. Hagney also pointed out, the Affordable Housing Trust Fund approved the overall financial plan that is before the commission, and that included the retail component. Now, in switching mid-subjects, in the past week, or to say a week ago, you asked us to prepare our own mathematical plan or approval condition or whatever for floor area adjustments. We did not do so for several reasons. The first is the commission has no standards, regulations, or as your discussion last week revealed, there is no established past practice as to comparability. I believe you will agree that there has been great variability, as I believe the chair's words were, as you're finding your way toward what you believe is equity. So we concluded that we would be negotiating against ourselves to try to come up with a formula. Respectfully, as you know, we also believe that there are some misunderstandings in the discussion on this issue. On top of that, backing into a model that would fit the highly variable floor areas in the current plan was found to be unworkable. And on top of that, we did check in with the Department of Housing, which said that they have never specified that all affordable and market rate units always have to be the same or virtually so. We decided instead to proceed.
Mr.
Yes.
Hollister, did they say anything else?
Yes, they did. They did, and they questioned whether 700 to 1,000 unit ratio in a development would be proper, and I said that might be pushing the limit in a rental development, but it was not in a for sale unit. But those are not numbers that we're dealing with. We're dealing with minimum numbers that are twice the example that they gave. Now, as explained already, I just said to Mr. Lowe, I believe, comparability is established here by the units being restricted in perpetuity, Schedule B of the affordability plan, distribution of units throughout the buildings, equal access to amenities, and minimum floor areas that will be the top of the market in Greenwich. These affordable units are not inferior in any way, and they will be a financial bargain to their purchasers by any metric. Now, question has come up, or the criticism, I should say, about units being in the rear of some of the floors. I would point out that those units may be the most desirable in the entire buildings because they will be away from the street and quieter. And please also notice that the smaller the unit, the less property tax and the less utility. It's easier to heat a smaller unit than it is a larger unit. So in affordability, smaller units has is maybe not a significant function, but a function in making the units affordable. Now, the next section of what I was going to say is basically what I talked about regarding the median incomes. I'm sorry, the median floor sizes. But the point that I was trying to make again is that these comparable ranges are a better measure of comparability across the two buildings than comparing the single smallest unit to the single largest unit in each building, which is, I believe, what your town planner has done in this analysis. In other words, the applicant should not be penalized for having large units, 2 bedrooms of more than 1750 square feet, and 3 bedrooms of more than 2,500 square feet, because these are the necessary result of shrinking the development from 92 to 75 units and the financial need to achieve the internal financial subsidy across fewer units. This redevelopment, as revised from 92 units to rental and sale of all 75 units, should also be considered one development. Indeed, our understanding is the commission demanded that the affordable units be equalized between the buildings, and that because the overall development should be considered as one, and that has been achieved. I think I alluded to this earlier, but there is a fundamental difference. There has to be a fundamental difference in comparability analysis between rental and for sale development. Designation of rental units as affordable is temporary. For sale designation is permanent. Accordingly, the unit sizes and everything else needs to be in a much tighter range in a rental development than for a for sale development. And that was the case when we had the rental building and the for sale building. And it is also why, referencing last week's conversation, the Benedict Place development that was referenced, that is, my understanding, is a rental unit, and that is not a proper comparison. But what is a proper comparison is your recent approval at 62 Mason Street, because that is for sale units. The smallest to smallest ratio floor size in that building is, we calculated at 71%, and the market rate units are 20 to 30% larger. The floor plans are not comparable, as the living room of one of the affordable units has no windows, and in what appears to be a direct violation of the Dowdy case that the chair referred to last week from Newtown, the affordable units have 1 bathroom for 2 bedrooms, and this development was just approved 2 years ago. Now, similarly, reference has been made
No,
to—
no, not 2 years ago, sorry.
It was
5
approved
years.
in 5 years, 4 or 5 years ago.
Yeah.
Madam Chair.
I'll
Yeah,
take
it's
that correction.
completed
Thank you.
now.
Yes, it
Okay,
is.
maybe that was I used the wrong word. All right, reference was made to the Wisnowski case for an 830G, an early case from the 1990s, and decision by Judge Berger. And I would ask you to commission to please note that in that case, the proposal was for a 32-lot single-family subdivision. The homes came in 5 layouts ranging from 1,460 square feet to 2,390 square feet. Judge Berger said, and I quote, "There is no unlawful discrepancy as to total size," unquote. He then went on to hold that the applicant's failure to finish the second floor of the affordable units was a comparable issue, but he was fine with the spread of a very large spread of the floor sizes in the units. Lastly, commissioners, and I thank you for letting me have some uninterrupted time to make these remarks. The commission's comments to date have sounded a theme of equity, but the plan is based on providing and maintaining the necessary financial subsidy while guaranteeing quality affordable units. The current application achieves this. The implication at times has been that the applicant is trying to hoodwink or take advantage of the affordable situation. That is not the case. That would not happen on my watch, and I believe there is no basis for these assertions. I will stop there, Madam Chair, and Commissioners, thank you for your time.
Mr. LaRoe,
Madam Chair, I had to, sorry, I have to do this, but I just want to clarify the intent of our analysis. It was in direct response to the applicant's analysis that their affordable units were within 80% of the smallest market rate units, and we could not replicate that for the commission. So we were trying to provide the analysis that was not given when that memo was stated and before the plans were given to us, quite frankly, if we go in the timeline of things. So it was not, I don't want anyone to hear this and think that we are trying to skew the numbers in a way that puts a bad light on anything. We were simply trying to accumulate, assimilate, and organize the units and describe them in the way that was being described to us in writing, and that's what the intent was. It was not to suggest that there is it basically was to close the gap on the math that wasn't provided originally. I would also point out that we, in the analysis we provided, it was comparing the smallest market to the smallest below market in the same unit. So we thought that was equitable because the arrangement and the sizes of the unit are not the same. So again, to the points of earlier conversations, to not have outliers, we thought keeping east and west was the most equitable sort of description. And you know, again, it wasn't to skew the numbers. It was just to keep sort of the unit styles on the west side and the unit styles on the east side, which were obviously similar because they're in the same building, to be sort of counted in the same way and not be thrown together in a bigger pool and then hopefully, you know, having or possibly having an outlier that's larger. That's my point on the analysis. And again, sorry if it's created more confusion than clarity, but that was the intent. I would just add that the reference to 62 Mason Street, that is a project that's all that is not below market, that has no government assistance. So it is a zoning application for a multifamily project. It's not an affordable as it's indicated in the analysis that was provided today. So I just want to clarify that point. So,
and also building
Yeah.
code doesn't allow units without windows. Don't forget that part. So now, so if
if I
somebody
could-
saw a unit without windows, that would be inappropriate. Now,
Madam
it would
Chair,
have
if I could
passed-
just,
wait, yes, go ahead, Mr. Hegney. Didn't your,
thank you.
didn't he talk already? Isn't it our turn right now?
I just
question,
wanted to
Mr.
respond
Mr.
to
Hollister?
Mr. LaRoe's comment. The
okay.
building at 62 Mason Street, just up the street from this, was a moderate income dwelling unit under 6-110.
Right, within our
And
zoning regs. That's his point.
whether it's counted as affordable by the state housing department or not, it's a good example of comparing a moderate income unit with a market unit. And when we compared them, we found both of them are on the first floor, both of them only, and they're all 2-bedroom units. Both of them, the MIDs only had 1 bathroom. They didn't have 2 bathrooms. And the one of the units is its living room, dining room, kitchen area is an interior room. The bedrooms have windows, but your living space doesn't. And size is as
I'm just
as
correcting
Mr. Hollister indicated.
Mr. Hollister indicated that the unit had A, he called it affordable. B, he said it had no windows. I'm just like bringing it back to facts. There's a, okay, just getting it back to the
difference
facts.
here is all the rest of the ones that were cited by the commission in its decision are rentals. And there are very few examples of it being a sale. And the only one that we found that's recent is the one on Mason Street, which the units are being sold. And
Mr. Hegney, wasn't 62 Mason a 6110?
Yeah.
Are
Yeah.
we talking about an 830G?
I did say that, Mr. Lowe, but I think it's interesting to note that the sales of the market units there, which are actually to some of them are smaller than what we're proposing as the affordable units, and there are MID units in that building are much smaller. One is 818 square feet. Our smallest 2-bedroom is 1,200, a little over 1,200 square feet. So we thought that was something that the commission had looked at recently, that is for sale, and that would be a good example for you to follow if you're going to go in the direction of comparability. Because
Well, if it were an
we would
830G,
submit to
I
you that
would agree with you.
our units are more much greater than what was approved at 62 Mason Street. And in terms of comparable, our affordable units are comparable to those market rate units. So when you look at the comparability, it's not just within the building itself, it's also what else is out there. And that's the information that I sent to Pat just a little while ago. And what it shows is that the size of the units that we're showing as affordable are comparable to the market units that are for sale currently in town and in other nearby communities. And that was the
Hegney,
point of submitting that information.
Mr. Hegney, isn't the discussion of comparability directed explicitly to units in the same building, not a building up the street? When we're talking about comparability, I don't know why we're introducing something that was 4 or 5 years old, and it was a 6110. It's a much smaller structure. My understanding, correct me if I'm wrong, I thought that's what comparability, the discussion of comparability was about in the same building.
Mr. Lowe, we were looking.
There's no requirement in the zoning regulations that we repeat something that we subsequently may view as a mistake. There's no requirement that we repeat our errors. Mr. LaRoe, and I'm sorry, then we'll go back to Mr. Hegney.
It's okay, Madam Chair.
All right, so Mr. Hegney, you were saying that
we were looking for consistency in comparing sale projects with each other. And the consistency we see is that we're actually providing something that is better than what the commission approved for a sale project just 5 years ago.
Yeah,
so that's why we're citing this as an example, both for the size of the units, comparability within that building itself, and how the commission found that was acceptable at the time.
So switching away into the rentals again, Mr. Hollister represented in one of in some memorandum that he wrote us that he has given advice that 70% of the size is acceptable. And I got to thinking about it over the weekend, and it occurred to me that he's been saying that because the rents in a rental building are an average of 70% of SMI. And that's how we came on the 70% number. I don't know if that's what you did, Mr. Hollister, but
No,
I
not at
would
all.
just like to remind you that in this case, we are dealing with a building that is supposed to be that the affordable component is priced at 80% of area median income. And the area median income is $144,000 a year, which is a very high income. So that it compared to SMI, which is, I think it's like 85. I've got the number here, but it's a very different situation. And so where you've been advising people that they can make buildings significantly smaller, I guess you're saying you weren't considering that. Okay, Mr. Hegney, anything else on that? I've got a few more points.
I did want to go over that and explain why we were using 62 Mason Street as an example.
Benedict is apparently approximately 90%. you all are choosing the sale issue. I've not to sell rather than rent. I'm not seeing anywhere where that changes what a commission does. Or I've not found anything that says, well, when it's a sale, they can be lots smaller. The apartments can be a lot smaller. I've not seen that anywhere. So I know you're laying that out as a hypothesis and you're potentially hoping to establish some kind of precedent, but I haven't found that in writing anywhere. That we should look at them differently when it's a sale. And that we should reduce the comparability. You've got nothing in fact, except that we once 5 years ago approved a workforce housing application in which the below market is smaller.
Madam Chair.
Yeah.
Sorry. Well,
Go
what
ahead.
I said in my remarks is that there is a fundamental difference between a rental and a for sale development, because the designation of rental units is temporary and the for sale unit, it's permanent. If you're familiar with what's called the next available unit rule, you could have 100 rental units and you designate 30 of them as affordable. And but in every affordability plan that I've ever done, and I think it's standard practice around the state, you say that if a tenant in if a tenant in an affordable unit qualifies income-wise in year one and then goes over income, you give them the choice.
Right.
They can move out or they can stay in
We're-
that unit and
Yes,
pay a market
we're
rate
aware
rent.
of that, right?
Oh,
You know that we
okay,
have
but
okay. Yes,
you asked me for the
but that doesn't,
justification.
no, but that doesn't, you're not obliged to make, as far as I know, there's nothing written that obliges you to make a condominium in perpetuity. There is no obligation to you to make it in perpetuity. I thought you were
Except-
doing it as, it's
well,
very difficult. I grant that logistically, I could see that it would be challenging. But again,
perpetuity refers to the length of the restriction.
yes, I know that. It's amazing. I speak English as a second language, but that I understood.
Madam Chair, I'm being respectful. Thank you.
I did not
For
feel
sale-
that you were.
For sale means that you don't change which units are affordable and which are market rate for the life of the development. That's a different subject.
Now, where is that written?
Because in the rental situation, you apply what's called the next available unit rule. In a sale situation, we don't want to, because where people have, probably made a significant equity investment, they've probably made physical modifications to their unit, which they're allowed to do to some degree. We don't want to ask them to move out if their income exceeds the original qualifying income. They can stay there for years sometimes, even though their income is over the limit. They decide when they move out, and then an affordable tenant comes in to take their place. In the rental situation, if you have one affordable unit that disappears because the tenant goes over income, and the tenant decides to stay and pay a market rate, to stay at the 30% level, the landlord's obligation is to make the next available unit in the complex an affordable unit, which could be a market rate unit.
Now,
That's
so
what's-
Mr. Hollister,
That's
is that
standard
written?
practice. That's standard
where?
practice in the industry.
Yeah, it's standard practice in the industry. Mr. Yeski?
Yes.
No, go ahead. I've got a couple more questions.
Standard practice in the industry, but not written. It's not a statute. It's not a federal law. This is, again, yes, I see the logistical rationale. I can see that. But again, we are not the ones asking for condominium. You have chosen to do this. You have chosen to commit them in perpetuity. We did not ask you for that. And I see your rationale, but we have not asked you for that. Mr. Yeski, I'm done. I'm sorry.
I just wanted to go back over. I've not seen Mr. Hegney's memo, but as I remember, there were 5 criteria for comparability, which is the percentage that we've been talking about, the 71% or some number like that. Is there a number, Mr. Hegney, that you came up with on that number one? Did you run that number? I didn't see the memo. So do you have that in the memo?
This is the memo that Mr. Hollister and I
Yes.
submitted
Oh, that memo.
to
Okay.
you. Yes.
I thought I was talking.
And as Mr. Hollister has said on a number of occasions during these hearings, the number that is accepted around the state is 65 to 70% of the market rate unit for an
Where is
affordable
it
unit in terms of
accepted?
square
Where
footage.
exactly is this accepted?
N'importe quoi. I mean, it's just, where is this accepted?
it-
Where
it
is
is-
it?
It is advice that I have given to my clients
Good.
consistently based on my experience and their experience in the marketplace, and the fact that that 30% floor area is generally inconsequential from one unit to the next. That's
Wow.
now you'd say, wow, Mr. Heskey, but you know, you asked me I was asked a couple of meetings ago, where's the case law on that? Well, there is no case law because
Right.
it's never an issue. That's a very common thing in the law. If it's not an issue, it doesn't become a contested court case. So all I can tell you is I've been involved in dozens and dozens of applications where I've given that advice, the developer has followed it, and the commission has had no problem with it.
Okay, so just one other thing, just to clarify for you. When you tried to compare the 6110 that we did on Mason Street, it's worth bearing in mind that we give zoning bonuses on a 6110. They are nowhere near comparable to the zoning bonus that you get on an 830G. The economics are completely different because the builder is trying to work within the zoning bonus we give, which is much more limited. So what the builder does and what they can achieve for economics may be very different than you who are going to 75 units in these two buildings. So very different situation because they are within our zoning regulations and a bonus applies. Now, I believe I think we've said it. We're struggling with a building of this magnitude, having over and over again, what we keep coming up with is we'd like to see equity, we'd like to see inclusion, we'd like to see comparability. I think each of us has said that in some way. There's one other point that I wanted to discuss with you, which is at the moment, your submission is not complete. You are missing, you don't show windows. Talk about not having windows in your apartments. You don't have windows. So, does anybody remember what the inconsistencies were? I'm blanking right now. It's
The windows shown on the plans, I went back actually deeply to old versions. Even the old versions from EDI do not show any windows. They show doors, no storefront windows, anything like that. That's kind of inconsistency. The floor plans and the elevations are not coordinated. Looking for a window, looking for a terrace on some of the buildings, or some of the buildings in elevation have show terraces and windows, but they're not on the plans. The fire marshal asked for a generator. We received a revised plan with a box and a label that said generator. I think it's actually kind of an incomplete thing, because I'd like to know, is the generator gas or diesel? Is the generator, as shown inside, vented to the outside in which direction? Where's the muffler go to? Those kind of things. That to me actually is a health and safety issue, because you're putting a generator on an interior building underneath residences. Let's see what else. I think actually because of the inconsistencies in the plans, I'm actually kind of concerned that the landscape plans may not be up to snuff, because they may be different because the plans are different.
and
There was no comprehensive sign plan for the retail, which is something we always would like to have, and that was never reviewed by ARC. So we really open-ended issue of retail use, but it's never been reviewed, Maryland looked at as a retail use, which actually is a major concern, because somewhere down the line, somebody's going to want a sign, and I don't know if it's been designed in or not.
And so technically, does that it's an incomplete.
Can't hear you.
Can't hear you.
Oh, that's weird. Can you hear me now?
Nope.
Huh. All right.
It's very low. I mean, we can hear you, but barely.
How's that?
Better.
Okay, so I'll shout. So technically, it's an incomplete application, but I don't even know, Patrick, it's not a health and safety issue if it's incomplete. Does an 830G have to be a complete application?
Well, I think it needs to be complete for the health and safety and the matters that the commission needs to consider.
Okay, so for this, we're just pointing out to the applicant that there's an inconsistent, that the elevations aren't consistent, that if you go from the floor plans to, there are differences. All we're pointing out is this hasn't been all tied down and completed, but it's not a health and safety issue. It's an incomplete application, but the matter is not a health and safety issue.
Well,
Okay.
Madam Chair, I would submit, we've submitted schematic level plans. That's what the commission generally looks at for a final site plan. We're not working with construction
Okay.
plans at this point. Same with the details for the generator. That would be part of what would be submitted with the construction documents. And no, we didn't go to ARC because
No,
even
but
though
that's
we
fine.
think it is
No.
a very, very good looking building and will be an asset to the town, whether the building is attractive or ugly is not a health and safety issue.
Madam,
Yes,
if I may, Madam, I think actually we as this planning commission are actually accustomed to having plans of all types, but the plans of all types that we get actually are coordinated. They don't change meeting to meeting unless we're looking at something. I have, a couple of different sets of elevations, renderings, floor plans that are all consistent. I just want to kind of put that on the record because I find it very difficult to make a decision if I can't kind of coordinate what I'm looking at and reviewing. I have mountains of information. Some of it actually is very detailed. Some of it is actually, like you said, Mr. Hegney, schematic at best. And I find that actually kind of a difficult situation for me.
Okay. Am I still audible?
Yes.
Yes.
All righty, good. Okay, so above all, we're trying to have a situation, and we've been saying this all along, that is equitable and has comparability and doesn't have a rich door and a poor door, and that doesn't have the affordable units in less desirable locations. I realize that the only state statute is, again, not clear enough, but this is what you're hearing over and over from us, that we're seeking comparability. We have not been the ones to press on the condominium issue. We recognize that it's valuable. I recognize that it's valuable to have a buying opportunity, but we are not directed anywhere that I know of to adjust how we look at an application because it is that. Nor are we required to do in perpetuity as opposed to 40. That doesn't say that. If the applicant would prefer to go back to 40, we're fine. We've never articulated to the applicant that we've got a high priority for retail continuity on this block. On these blocks, we've never said that. So this is something that comes from you. We've mentioned that the plans are not complete in the sense that they are not to the standard. I couldn't figure out what related to what and what dates were right and what was the most recent. We've mentioned that there is an inferral from the case law that Mr. Hollister quoted, that because an 830G can't be used to bootstrap the commercial use, that therefore an accessory commercial use, that he has inferred that therefore a commercial use that is accessory is acceptable. There's no evidence for that anywhere. So we still question that. I heard us question it. Again, we've raised the point that this project is for 80% of AMI, which is a high income level. And I was going to pull out the numbers because I have them here. Not finding. Okay. The 144,000 a year is compared to 85,000 a year. Pretty significant difference. And that's the benefit that the applicant has. So we're making an effort to advance affordable housing by having this government-assisted approach. Mr. Hollister, when you first heard about it, you liked it. That was way back when we were doing the Ironworks application and you were considering litigating that. That's it for me. Those are the key points I wanted to raise and to go back over. Is there anything else the commission would like to say? Dennis, you were waiting to speak? No? Did you want to put in?
You covered it.
Okay. Anybody else on the commission? Have we allowed you to put everything you wanted on the record, Mr. Hegney and Mr. Hollister?
We've addressed the points that the commission had in its denial letter back in September, and we have discussed with you our position regarding the two issues that were discussed at the briefing yesterday. I really wanted to add, though, that I think that this is a building that will be an asset to the town. It is in the right location. It's a block from the train station, block from the bus station, the bus stop. And this is the kind of project with ownership that the commission has not yet seen, and I think is something to be encouraged rather than discouraged.
Well, I agree with you that it is an advantage to have it being in that central location and so accessible to transit. As you know, we've approved a very large 830G that is not particularly transit accessible, and that was a concern. In that event, if you have both been allowed to establish your record, I'd like to turn to the public for comment because we do have people here. Does anybody wish to speak on this application? Mr. Collins, I saw you raised your hand earlier. It came back down. You're up. Anybody else who wishes to speak? The person, John, okay, so Mr. Collins is first. If you would unmute, you are followed by John Dooge. I hope I got your name right. If the person who's noted as being iPhone 4, we're going to ask you to spell your first and last name. Mr. Collins, you're rustling paper.
Sorry.
And then Ken, when you come in again, you'll have to add your last name, and then Diana Dowling. So first, Mr. Collins, and then John Dooge. Go ahead, Mr. Collins.
Good evening, everyone. Thanks for taking the time. Again, thanks to the commission and the chair for all the energy and the great insights. So unfortunately, I wasn't really able to go through the presentation of today because the time was very short. So most of my comments are based on the one on the presentation from 12/12. In any case, I'm going to speak quickly and try and keep it brief. And I want to go directly to issues that have bearing on public health and safety issues. I'm going to leave out the traffic and we don't like it and all the NIMBYs and all that kind of stuff. But the point here is there's some things going on here. Environmental remediation. The way I read the documents, Connecticut DEEP does not have, it's on page 133 of the application. It says, whereas the commission notes that the environmental site investigation, while reportedly ongoing, and we know that Langen and everybody else and various consultants and licensed environmental professionals are working on this, has not been completed, and a remedial action plan has not been submitted nor approved by the Connecticut DEEP. I think it's incumbent on the team to do that. You've got very sophisticated, very intelligent people on your side. Can we just get this done? Okay, traffic. No matter how much we bring up the fact that there is a large residential development on the corner of Havemeyer and Millbank, nobody seems on the applicant's side wishes to address the fact that these apartments are being occupied, which I can confirm as a witness by walking by with my little doggie at night, and I see the lights are starting to come on, and the virtual doormen are active, and cars are going in and out. And as predictable, FedEx and Verizon and UPS don't know how to get in and out, and they're constantly on the street scratching their heads. I would say that this is a problem we may also anticipate for this project, because in no way have approach lanes, exit lanes, and so on been incorporated so far as I can tell. Okay. So further, the traffic, that's what I mean, is the traffic study has to be updated. All right. Now, this traffic island in the middle of Bruce Park Avenue, which the town has approved, and they say it's going to be great. And it's just like the one that's right in front of 101 Field Point Road, which all of the commission is going to be driving over when they leave tonight. I don't think you can reasonably compare the kind of traffic or the volume of traffic and the number of pedestrians that are recrossing at Bruce Park Avenue, intersecting with Mason Street. People are coming off of 95. They're going onto 95. They are in a hurry. They're trying to get into the parking lots to get on their trains down to New York, wherever they go. Metro North is once again a player after the pandemic interlude. And I think we need to take that into account. And I would respectfully say that, common sense, and especially good urban planning sense, would require the applicant to redo this traffic study with somebody who perhaps is a little bit more attuned to what is happening, because the presentation 2 hearings back by that traffic consultant was so underwhelming. I'm wondering why he was retained. He had trouble articulating. He was difficult to understand. And I really felt it was inappropriate for a high profile project such as this one. Okay. The people who are going there, they want to hit the gas. I testified this before the hearing before last. It's like a hill climb. They really want to get out of there, or they really want to get to where they're going. So if we are having traffic that backs up the hill in the easterly direction for the westerly flowing traffic, what they're going to do is turn right onto Ridge Street, and then they're really going to be in a hurry, because now they got to drive more blocks. This is the kind of behavior that causes pedestrian deaths all over New York City, and we know all about it. In fact, it was a Greenwich resident who was the commissioner for many years who instituted some really innovative traffic calming matters there, some remedial measures. And I was quite surprised that, a lifelong mover through New York City, 20-something year resident here in Greenwich. And there's a lot that can be done here. The creativity level here is, it needs to get stepped up. So, what's going to happen is, as soon as this goes online and the traffic on Ridge Street becomes really unbearable, if I'm still around, I'm going to get a committee together. We're going to try and change that street to one way going in the southbound direction. This is clearly a reaction and a symptom to the effort to urbanize this corner of Greenwich. Now, I'd also like to say I'm in favor of housing close to the highway, close to the parking, close to Metro North. It's lovely, but I think it needs to be done with a sense of urban planning, not with a sense of maximizing the profit that goes into the pockets of this developer, this applicant named Joss Caspi, who definitely doesn't need it. I agree the buildings are attractive. The 6th floor is also going to be looking into the backyards of my neighbors. Okay. And that's a very interesting thing to think about, because let's talk about the setbacks for a minute. I'm jumping ahead. I have a whole written essay again.
We were going to ask you not to try to keep your points brief, because we've got 4 other people who would like to speak.
Yeah, I know, but I know Mr. Caspi was able to speak when he wanted to the
Yes,
last
but
time.
he's the applicant, and
I understand that.
yeah,
But,
and the attorneys can also talk as long as they want to, even though we might sometimes interrupt them. But if you would,
Okay.
Mr. Collins, we would be grateful if you could keep it short.
Yes, ma'am. I'll go faster.
Thank you.
Setbacks. Setbacks are for introducing light and air and creating high quality housing. Using a strange argument, which is sophistry, that we're going to measure to where the retail business starts way deep inside a building, is ignoring the fact that we would like to have quality housing in Greenwich. When people open their windows, they are not going to have a cliff with retaining walls that they can maybe reach out with their hands and touch. And I would really love to know that all the affordable units are not on the lower levels, where the rear yard setback, which should be 25, is only going to be 8 or 6 or something that I don't know. The setbacks are not being observed. And we can see that on pages 3 and 5 of the presentation package. Okay. So the last one on the parking, I would urge the commission to require that this not be one project. The parking for each building should be inside that building, so we can avoid the crossing of the street by the elderly, the overloaded, the pregnant, the disabled, the young, people carrying their packages and so on and so forth. That's been spoken to a number of times, so I won't dwell on it. But you know, and one of Mr. Hollister's writing, he said, well, it's not enough to say no. We have to suggest stuff. Well, I have a suggestion for you. Let's put a bridge between the two buildings so the people don't have to get run over or get wet or get snowed on or get blown away by high winds or God knows what. Or if you don't want to do a bridge because the trucks get stuck on it, which is always an issue here in Greenwich, I've seen it a lot, a nice tunnel from one parking lot to the other. So I will send this, which has more stuff in it. Thank you for your time.
Thank you. And Mr. Collins,
Good night
so
to
you
all.
know, and thank you, Mr. Collins. So you know, in a previous iteration, we did ask them to split the parking into the two buildings more evenly. We've asked them to make this 2 separate applications that can be, et cetera. We've gone down this road on other iterations, and the applicant has not wanted to, and the state statute allows them to do this. But thank you, sir.
Understood, ma'am. Thank you.
Thank you very much.
Yeah. Good
Our
night.
next speaker is John Duge. If I just could ask you as well to, you know, if you could be succinct. Again, you're entitled to speak, but if you would just be succinct and unmute and go ahead. Mr. Duge, if you would unmute. All right. Okay, I'm going to move on. Since John Duge doesn't seem to be able to unmute, I'm going to move on to iPhone 4, and you'll need to say your first and last name and spell them for the court reporter.
Hi, my name is Ivana Sabar, I-V-A-N-A. Hi.
Ilana,
Sorry.
right?
Ivana, I-V as in
Ivana.
Victor, A-N as in Nancy, A, Sabar, S-A-B as in boy, A-R as in Roger.
There she goes. Patrick's very fast at this. Okay, hello, Ms. Zabar. Welcome
Okay.
back. And go
All
ahead.
right. Thank you. The word absurd was introduced previously in this meeting, and I mean no disrespect to anyone here, but here is what I believe is absurd. Invoking 830G in a project like this to leverage a state law meant to provide affordable housing to build high-density buildings in Greenwich. Every Greenwich resident who I speak to about this, from those that support affordable housing and those that do not, think it's quote unquote absurd to build projects of this size in downtown Greenwich. Most of them don't want to be vilified or labeled NIMBYs and don't speak up as a result, which I understand completely. I don't want to be either. But I have commented in nearly every P&Z meeting because the safety of the roads as a driver and pedestrian is deeply personal. The only reason why my daughter is here today is because her shoelaces happened to be untied when an SUV drove into the crosswalk where she would have been otherwise. This was just a block down from the corner of Mason and Havmeyer, where there are actual pedestrian lights. The corner of Mason and Havmeyer is not a place where I would allow my daughter to walk by herself under any circumstances, and I myself avoid crossing there as well. This also applies to the stretch of Mason, which this project is going to be a large part of. Secondly, a $42 million subsidy was mentioned, and that is an interesting number. If this is a subsidy, I think what would also be an interesting number is what the developer stands to make by leveraging 830G and how much they would stand to make by building a project that is appropriate to the site. Finally, this just, as a resident, feels like madness. All of these high density projects going up or being put up for approval that are a size appropriate for cities and not towns. It makes more sense for a 20 to 30 purely affordable housing building, which under 830G would be around 800 total units in total, to be built at the Mason Street project site. 52 Mason, which was already cited, is a reasonable size. It's a nice looking building. It's been there for as long as I can remember. And I, as a resident, can't understand why projects like these cannot be ones that are being approved or talked about or planned for to address affordable housing in Greenwich. Thank you for your time.
Thank you, Ms. Zabar. The next speaker is Ken Wheeler. Go ahead, Mr. Wheeler. Thank you, sir.
Good evening. My name is Ken Wheeler. Thank you for this opportunity to speak in my capacity as a town resident. The 830G statute requires that prior to the P&Z Commission's approval, all health and safety issues are guaranteed to all buildings and all town residents. This application in its current state does not meet this standard. The residents of 20 apartments in the West Building still have to exit their building, walk up the street, cross a busy Mason Street, possibly in inclement weather and rush hour traffic, into the East Building's underground garage every time they need to use their vehicle to go somewhere. Perhaps an elderly or handicapped resident or a parent with multiple children with their arms full will have to do this. This is a safety issue, and it will result in a more dangerous situation for that area of the town and for residents using it. Another traffic concern for all residents who will drive through, walk through, or live in the area of Lower Mason Street and Mason Street Bruce Park Avenue intersection is not only the increased amount of vehicular traffic, but also the reconstructing of our town's roads, sidewalks, and traffic patterns, which is also proposed for this much larger and more complicated than usual project. The proposed street and sidewalk changes to the area will cause vehicles to use other means. Speeding down alternate roads and intersections will happen in order to avoid this redesigned area and the traffic backups that will occur. This, again, is a state safety issue, and it will result in a more dangerous situation for that area of the town and for the residents using it. These traffic safety concerns are certain to occur not only during the multiple years of construction that this project is sure to take, but also when the buildings are fully occupied with hundreds of more residents living in a very small area. Along with this building, there are several other multifamily dwellings either being built or being proposed to being built. There will certainly be a large amount of delivery vehicles and vehicles from different service calls that will occur at any given day that will clog up the area. During construction, there's bound to be an incredible amount of material deliveries, utility and service work, crane access, and equipment mobilization and worker vehicle issues. This will alter traffic patterns and cause road closures, congestion, and traffic chaos during the construction for the life of the building. This, again, is a safety issue, and it will result in a more dangerous situation for that area of the town and for the residents using it. This commission has already previously denied this application, and that decision was necessary to protect substantial public interests in health and safety. Nothing has changed since that denial. Along with the unanswered questions pertaining to retail use or building setbacks and zoning compliance, unit comparability, the added strain to traffic patterns and stormwater drainage, and the question of contaminated soil, I believe it has been demonstrated that this development from the beginning of construction onward will pose a health and safety risk for the area and will change our town in a negative way forever. In discussion with neighbors and residents around town about this project, while not being opposed to affordable housing, just the 830G provisions, I have yet to hear any resident who is in favor of such tall and voluminous buildings, not to mention the redesigning and reconstruction of roads, sidewalks, and crosswalks surrounding it. The installation of raised traffic islands and curb and crosswalk extensions don't seem to be too popular or desirable with many town residents lately. And to do so in order to compensate 5- and 6-story buildings towering over the whole area of town is sure to bring public outcry. In fact, we appreciate and share the applicant's concern for providing affordable housing, but encourage him and his team to achieve it through the construction of zoning compliant buildings. And we feel that the 830G statute just may be being used to hoodwink zoning compliance here. Now, I know the 830G statute is state law, but 830G statute or not, if approved, once construction begins, there will be much public criticism aimed at you, the commission, for allowing this to happen. And it will be perceived that you are not looking after the best interests of the town's residents. If this application is approved, Riverside, Byram, Coscob, and Old Greenwich will be next. Is this commission prepared to open the way for the beginning of a transformation of Greenwich into a city under their watch? Thank you, as always, to the commission members, the planning and zoning staff. Merry Christmas and happy holidays to you all.
Thank you, Mr. Wheeler. Our next speaker is Diana Dowling.
Hi, yes, Diana Dowling. Look, the speakers before me were unbelievably articulate in terms of identifying all the key issues that we're all very familiar with. I can't add any additional facts or points to what they say, but I will just add that at the end of the day, we're looking at two very tall, very oversized buildings crammed into a very tight space in our town. And it's dangerous. It's too compact. There's too many pedestrians and there are too many cars for that space. And I think it will have ramifications in terms of our overall downtown look. And I think to Ken's point, it will have ramifications for how the rest of Greenwich gets approached as people think about developing 830G projects. And they too say, hey, it doesn't matter whether there's an issue of too dense buildings and threats to safety. So I just feel like we just hope that everybody can step back for a moment here and say, look, we just need to do what's right here. Thank you.
Thank you very much, Ms. Dowling. Janine Forrest is next.
Hi.
Oops, I'm sorry. Let me just do that again. Okay, go ahead, Ms. Forrest. I goofed. Go ahead.
All good? Am I unmuted?
Yeah, I hit the wrong person.
Thank you all for your time and attention again into the evening for this. I'm speaking again to strongly oppose this. Absurd seems to be the word of the evening, which is an accurate one to the developers. Absurd development in our neighborhood. This project poses severe risks and negative impacts that will drastically affect the quality of life for the residents and the safety of our community. While Mr. Hagney stated that he responded to the initial denial as it related to environment, fire, and traffic, I do not believe those issues have been properly addressed by the applicants or respectfully by the town of Greenwich. As all the previous speakers have said, the traffic congestion and safety concerns are still there. The addition of this development will exacerbate already significant traffic congestion in the area. Our roads are just not equipped to handle the increased volume, particularly during the peak hours. Furthermore, the traffic added creates a dangerous situation for pedestrians, including my children and myself, who walk to the metro station every day and have almost been hit by cars multiple times due to improper sidewalks, due to the improper crossing. The construction of the plaza alone has caused continued issues of me having to walk down the street. And to add to that, the new structure on Millbank and Havemeyer is less than a half a mile away, is already going to add hundreds of cars to this already congested area. And as I stated before, the new plaza hasn't even been opened to further add to the traffic problem. Nothing has been presented to mediate the traffic issue besides, as previously stated, a less than adequate traffic study. This alone should delay any approvals on this project. Last week alone, I was almost involved in a head-on collision while turning onto Ridge from a speeding construction vehicle with no regards to our traffic laws whatsoever or to the safety of myself or my children in the car. I've already addressed fire safety risks in previous speeches in regards to this, and I don't think that has been addressed either. Navigating these crowded roads is going to be a nightmare for emergency service vehicles. Last but not least, as previously stated, it's just not the right thing to do. It's a degradation of our neighborhood enjoyment We've barely survived 3 new houses on Havemeyer, the unlimited, I believe, 5 count currently going up on Locust, and the 2 on Ridge. We've just survived the construction of Millbank, and now you're going to add this noise pollution, environment pollution, and traffic on top of us. I strongly urge the town of Greenwich to stop entertaining these absurd projects like this that fail to account for the community's needs and well-being. Any proposed developments should prioritize meeting the current residents' safety, character, and quality of life. And I ask that you reject this proposal and refocus on sustainable growth that respects the unique fabric of our community. Thank you for considering these critical concerns. And as Mr. Wheeler said, I do wish all of your family a very happy holiday season. The time that you have spent trying to mediate this is much appreciated. Thank you.
I love your last line, sustainable growth to support the unique fabric of the community. That's, we're going to have to, that's a great one for the POCD, Dennis, to
Thank you.
combine sustain. Thank you, ma'am. Our next speaker is John Duge. And I hope you're able to unmute this time, Mr. Duge. Go ahead.
Hello, can you hear me?
Yes, sir. Great.
Okay, thank you. First, I'd like to thank all the commissioners. My grandfather served on the Planning and Zoning Commission for 37 years.
Wow.
So I appreciate, yep. And so I can appreciate all the many hours you contribute to the service of the town. I own the building across the street, across Bruce Park Avenue from this project at 20 to 22 Bruce Park Avenue.
Mm-hmm.
My great-grandfather built the building and we have our family business there. And my shop doors are actually still an active driveway. Those doors open up and they're carriage house doors. And I bring my truck in and out of there. And so that raised pedestrian refuge island, I don't see how that would work with my driveway there. That would be blocking my driveway. And I don't know, you know, what they can do around that. But
we can raise the concern with DPW traffic. We can have them look at that. They may not have identified that you have an active driveway there.
They probably aware that driveway, but it is.
Okay. All right.
The other concerns, also with that walkway, I saw it looked like they wanted to have a post with like a flashing strobe light or something for when people use the crosswalk. It looked like where they were planning on placing that post would wind up right outside my tenant's bedroom window. And I feel like that would be health and safety concerns. It would impact people's sleep to have a strobe light outside your, 1 or 2 feet from your bedroom window.
Okay.
And so I don't know how that would function, if that can be removed and what impact that has on the project.
All right.
Other questions is just having such tall high rises on both sides of Mason Street. My building is sort of right in line with Mason Street, and I was concerned with any wind effects. I know sometimes in cities with high-rise construction, that's part of the reason that they have like revolving doors and stuff like that. It affects people can't open or close their doors. I don't know if these buildings are tall enough to trigger any of those effects. I know they're not skyscrapers, but we're not really used to many high rises in this area, and I don't know any wind effects that might come into play. And then also just the parking. The retail, I feel like the customers for the retail space are going to be wanting to park probably on the street rather than underground. That's going to overload the little parking we do have at the bottom of the Greenwich Avenue. We don't have the parking behind the buildings like the middle and upper avenue have. So it's going to be very tough on parking, and they're removing spaces. I'm not sure how many in the latest thing. I thought it was 8 or 11 or something like that. But for them to be removing roughly 10 spaces and then adding a bunch of additional demand for spaces from their retail customers. And I would also imagine additional demand for spaces from the residential tenants, because these are 2-family and 2-bedroom and 3-bedroom units. These are going to have multiple adults with cars, most likely. And if you've got 75 assigned spaces for 75 apartments, that's great. But if you have 2 drivers in each of those households, that's another 75 cars looking for a parking space in the neighborhood. And you're going to remove the minimal parking we have in the neighborhood. You're taking that away, and then you're adding roughly 100 new drivers looking for spaces. And they're going to drive through, they're not going to find a space, and then they're going to start circling the block, and they're going to be driving on Ridge Street. They're going to be driving in the residential side over the hill on Bruce Park Avenue. It's just going to overwhelm the traffic in all the neighborhoods too. And so that's also going to be a health and safety issue, having all these cars circling looking for parking spaces. So I feel like that's a health and safety matter too. And just living in the area, I know, my tenants rely on the street parking. The neighboring buildings on Bruce Park Avenue, they rely and share on the street parking. I know people who live in Greenwich Avenue apartments, they park their cars back there. Employees of the Greenwich Avenue businesses, they're back there sometimes. But all these people, the whole community relies on that minimal parking that we all share. And to have that, number one, taken away and then overburdened is going to be hard on everybody. And I know it doesn't count towards 830G, but, most of the people who live down here meet those affordability guidelines. They're renting small apartments, and if they go and these apartments aren't viable as residential apartments because people can't bring their groceries, they can't park 3 blocks away to bring their groceries in, and we end up losing the affordable apartments that we have now.
Yes.
That people only need, somewhere $5,000 to $10,000 of a first month's rent and down payment to move into, and $2,500 a month, and we're giving that up and losing that to have something that people need 100,000 and $4,000 or $5,000 a month to move into.
Yeah, we call it naturally occurring affordable housing, and this is a big thing that we lose it as the town gets developed by newer, and sometimes even though they're called affordable, more expensive. Mr. Doogie, and I find now that I know you're the building, it's Doogie, right?
Doogie, yes.
Yeah. So we can't mandate the parking on this type of application. It's done by state law. I recognize what you're saying, that if it's all 2 and 3 bedroom apartments, the parking could be tight, but we can't mandate anything on it. We are,
Okay.
so we can't respond to that. Is there any other point you'd like to make?
Those were my main points.
Thank you very much, sir.
Okay.
Our last speaker is Gwen Briggs. Ma'am, if you would go ahead. And you just need to unmute. Ms. Briggs? Ms. Briggs, are you able to unmute? Somebody's making noise, but it's not her. Ms. Briggs, are you able to unmute? Gwen Briggs? She may have walked away while she was waiting. Okay. While we give Ms. Briggs a couple of minutes, is there anything the attorneys would like to put on the record before we? Or actually, first, let me just go to anything further from the commission. All right. And from the attorneys?
Madam Chair, there's a demonstrated need for affordable housing in Greenwich. I know the commission's aware of that. There've been many studies done, and it's not just for it's a full range of affordable housing and market housing that's needed here. This building doesn't answer all of those issues, but it has it would have a significant impact on providing purchase affordable housing on an AMI level and provide market housing as well in an area where people are looking to have housing. And we believe that this is a building that will certainly be an asset to the lower part of Greenwich Avenue. And we urge you to support it and approve it.
Thank you,
Madam-
Mr. Hegney. I believe
Madam-
that our affordable housing plan makes the same points, and we agree that we are doing our best to advance affordable housing. Mr. Hollister.
I just wanted to remind the commission that we have a Connecticut Supreme Court case that said that comparability is not a denial reason. It's a matter of opinion that can be dealt with reasonable changes and conditions. And that's true really of everything that was brought up in the last hour. So if you're not inclined, if you're inclined to have remaining concerns, those should be dealt with by reasonable changes or conditions. Thank you.
So, Mr. Hollister, we used to have an applicant that would come and give us the regulations, and he would print them in color in really big block letters, and he would tell us our regulations as well. Yes, we are cognizant that you sent us this memo, and it's in the record advising us of what the situation was. Ms. Briggs, I see you've unmuted and you're ready to go.
Hey, is it working?
It's working. You're ready to go.
Okay, it wasn't working on my phone for some reason. Okay. I just wanted to, I'm sorry, let me turn off my phone, was still on. I am a lifelong Greenwich resident and I reside on Ridge Street. And I'm very concerned about I know a number of safety and health issues have been raised. And I don't see that there has been an adequate place to put a crosswalk on Mason Street near the project. I don't know if the commission or
We did. We're asking, yes, we did. We asked for a crosswalk on Mason Street to accommodate that people were going to have to go to the parking.
Right, no, I understand that, but there are five, I had written that there are 5 active driveways on the west side. I just drove down tonight. There are actually 7 because there is the one at the Honda dealership, the one that goes down the alley to the back of Greenwich Avenue, the dry cleaners, which is a double cutout there. There is another driveway next to that building, next to the dry cleaners. Then you have the auto shop, which has a bay window and another driveway. So I believe there are actually 7. And so a crosswalk anywhere on that block is going to be next to a driveway, which I don't think is safe. I think it's really scary the way people also drive. If you were to put it closer to the corner of Mason and Bruce Park Avenue, coming down the hill to make a right-hand turn, is going to be very difficult to see with the building that's going to be blocking your view there. So that is one of my.
Ms. Briggs?
Can you hear me?
Yeah, there, you're back.
I know, I don't know what's going on here.
That's okay. We got it. Okay, so we got that one.
The other, I don't think anybody has taken into consideration or has mentioned in the past, the Connecticut Transit bus. Now, I know there's been talks of doing curb cuts and bump outs on the corner of Mason and Bruce Park Avenue. Now, those transit buses are the articulated buses that are 60 feet long. And I don't know if anybody remembers, I thought it was just a couple years ago, but it was in 2016. A bus was coming down Mason Street to take a right onto Bruce Park Avenue. Same Connecticut Transit bus was coming up Bruce Park Avenue, making a left on Mason. There is not enough room for both of them to turn safely. One bus backed up. It took out the utility pole. 470 residents and commercial properties were without power. for a few hours. So making that narrower there is going to just diminish the turning radius for large vehicles, not only just the buses, or you have school buses, you have delivery trucks, you have 18-wheelers that might be coming through there. So I think that is a very big concern, and I think the curb cuts are really going to be a safety concern. So that
Okay.
really needs to be looked into. Okay.
Okay.
Now, my other concern is the noise and fumes from the massive, the generators that are going to be on the buildings. I know that Mr. McRae also brought that up, but not knowing, is it going to be diesel? Is it going to be natural gas? There's going to be exhaust coming out, and the residents of our street and the neighboring area are going to be, ingesting those fumes. We're also thinking about the quality of life, using our outdoor living spaces, having to listen to the noise of those generators and smelling fumes when you're trying to enjoy your backyard or your porch, is a big concern for me also. I did hear there have been a lot of complaints from residents down in the Bruce Park area about the Berkeley building, which is across from the Bruce Museum. That it's very loud. And also one other item is the service delivery trucks who use Mason Street. I don't know if people are aware of how many trucks park at that end of that block on Mason Street. They do make deliveries to some of the restaurants. There's food trucks, there could be liquor trucks, linens, garbage trucks. Not to name the Amazon, the FedEx, and all those. So just knowing that the traffic is going to be very increased there with the amount of cars coming in and out of those buildings, and if there's retail. So that is a very big concern, and those trucks will also obstruct the view of people pulling out of driveways or the crosswalk, wherever that crosswalk may go. That's another concern. And then just the amount of noise coming from a 75, if they have public amenities in the project, they're going to have a rooftop deck, an outdoor patio with a fire pit where large numbers could gather. Are there going to be noise restrictions on amplified music there? Again, this, is affecting the quality of life for the residents of Ridge Street and then Bruce Park Avenue and Mason. And then again, I know the fire on Ridge Street has been brought up many times. I was down there on Mason Street the next morning speaking to a fireman from Stamford who said there was no way they would have ever been able to get to the back of that structure if they didn't have access to the open parking lot. There was a building there. Who knows how catastrophic that fire could have become, maybe spreading to the other homes. And then again, back to just one of my major concerns, of course, is the size and the scope of this project and the negative effect it's going to have on residential property values on the streets in the surrounding area. Over the recent years, downtown Greenwich has seen a huge increase in multi-million-dollar properties, which in turn have wielded high revenue and property tax for the town. What you're essentially doing is killing the goose that lays the golden egg. A building of this size is going to destroy the value of the properties of those on Ridge Street. These $5, $6, $7 million homes, which are directly behind it, are now going to have to face a 6-story building when looking out their back windows, rather than having a view of the skyline and also the gorgeous sunsets that we often have on being up on the hill. And again, I would just really like to urge P&Z to not approve this project. It's, many residents moved here for the beautiful character of this town. It's being destroyed by the huge developments, and soon will look like any other, urban city. And we would really love for the town to preserve as we know it. And I don't think any resident moved here to Greenwich with hopes that high rises would be built. So I again urge you to please consider the residents of Greenwich, the health and safety. And I thank you for your time. And that is all.
Okay, thank you,
Okay,
ma'am.
thank you.
All righty, so we can address some of these issues with the driveway, I think with DPW directly, right, Patrick, with the crosswalks and where they're positioned relative to the driveways, that can be done with DPW and just have them review where those locations are and have it worked out with the applicant prior to permit? Is
Yeah,
that
I'm not
if we
aware
were
of an
to
issue
move
with
this
the
forward?
crosswalks.
Okay. All right. All right.
Madam Chair, I'd
Yeah.
like to address that one point.
Mhm.
We've had numerous discussions with town's traffic and
Mhm.
civil engineers, and met out on the property and took out a measuring tape and looked at what would work and what wouldn't work, and how it would not impact other people using the intersections, and the safest place to have a crosswalk and how it relates between the two buildings. We have had those discussions, and I believe that the memo you received from the town traffic engineer spells out that we have actually addressed these issues. If there's a change that needs to be made, we're happy to do that as well.
That's what I'm thinking. If there's something somebody missed, well, it can always be revisited if this were to move forward prior to permit. Nothing further from the attorneys? Anything further from the commission? Does anybody object to closing this application at this time? I see no objection. Therefore, this application is now closed. And I would suggest that we go ahead and consider and make a decision, try to reach a decision at this time. In so doing, just going to remind everybody that seated on this application are Albin, Macri, Wells, Lowe, and Yeski. That Mr. Levy is no longer on the commission and was previously seated on this application. Mr. Wells has attended all the meetings and is familiar with everything that has transpired, and has now officially, this is his second meeting as a regular member of the commission, replacing Mr. Levy. I'd like to suggest that I put forward a motion to you that we get a second on it, we discuss it, and we see how we do. And I apologize, it's a long one. Tracy, I sent you a copy of, I kept finding typos, so I think I got them all, but I sent you a copy if you would share it with the commission, share it on screen. So let me kill this screen for myself. So as to the application.
Can you see that?
Yes.
So I can make it a little bigger, I think.
No, I've got my glasses on. I'm good. Everybody else can see it. See, I missed a typo. I see it already.
That's all right. We'll
Yeah, it'll get fixed. As to the application of Mason Street Partners LLC for a final site plan and special permit to develop properties on the east and west side of Mason Street for a mixed-unit residential and commercial assisted housing development per Section 830G of the Connecticut State Statutes. 2 buildings are proposed. Their first floors would contain commercial uses. Their upper floors would be all residential with a total of 75 residential units, where 12 units in each building, 32% of the total unit count, would be below market, deed restricted in perpetuity. The west side parcel is located at 405 Greenwich Avenue, 290 to 294 Mason Street, and is 15,783 square feet in total lot area, and within the CGBR, CGB, and CGIO zones. The east side parcel is found at 275 to 289 and 309, 321 Mason Street, has a total lot area of 53,885 square feet, and is within the CGB and CGIO zones. This application is a modification being filed according to Connecticut State Statutes 830G subsection H. The west side building appears to be non-conforming as to required front and street side yard setbacks. The east side building appears nonconforming as to the rear yard setback. Lot and building coverages for both proposed structures are also nonconforming. Whereas zoning statistics have not been submitted for the building being retained at 405 Greenwich Avenue. Whereas the commission notes that the subject application is not accompanied by a comprehensive set of architectural drawings. The materials submitted are inconsistent in the data they provide, particularly as pertains to consistency between the proposed floor plans and exterior elevations. And as an example, the floor plans do not show any windows in the units. Whereas the town's 2022 Affordable Housing Plan, adopted pursuant to CGS 830A, seeks to affirmatively further affordable housing, and whereas advancing affordable housing is an ongoing commitment for the Planning and Zoning Commission. Whereas since adopting the 2022 Affordable Housing Plan, the Commission has granted final or preliminary approval for 656 units in 9 developments having below market housing as follows: 120 units with 40% affordable on Benedict Court and Benedict Place, 35 units with 20% affordable on Oak Ridge Street, 10 units with 30% affordable on Hamilton Avenue, 6 units with 30% affordable also on Hamilton Avenue, 52 units with 100% affordable senior housing on Vinci Place, 10 units with 20% affordable on Pemberwick Road, 212 units with 30% affordable, 198 unit development, which will be contributing a fee in lieu of affordable units, and a 13 unit building with 20% workforce housing. Whereas Greenwich also enables accessory housing units and 2-family residences as of right. Whereas Greenwich has also added almost 100 affordable housing units since 2020, raising its percentage of affordable housing from 5.35% to 5.73%. Whereas in 2023, Greenwich had a higher percentage of affordable housing than 109 of Connecticut's, lots of typos, of Connecticut's 169 towns, placing Greenwich near the top third of all Connecticut towns. Greenwich's 2023 affordable housing percentage was also the 5th highest of the 23 towns in Fairfield County. Whereas the subject sites have been occupied by a gasoline station, a stone cutting facility, and automobile sales and repair businesses. Whereas Phase 1 and limited Phase 2 environmental site assessments for the subject properties were completed in 2022. Whereas several areas of concern, AOCs, were identified in which releases of oil or hazardous substances may have occurred, and for which there was also olfactory evidence. Whereas the applicant's engineer and the commission's consultant agreed that additional investigations must be completed. Whereas the applicant's environmental consultant has stated remediation and redevelopment of the site may proceed concurrently. Whereas the applicant has advised that the remedial action plan will incorporate all measures required by Connecticut DEEP, such as full-time oversight by an environmental professional, odor and dust control, truck traffic management, and continuous monitoring. Whereas Fuss and O'Neill commented that since the limited Phase 2 ESI was conducted in 2022, the DEEP has notified the regulated community that sampling for emerging contaminants will be required and recommended. Langen determined if sampling for these groups of contaminants should be conducted. The presence of these COCs, specifically PFAS, could have a significant financial implication for soil and groundwater remediation. Whereas the commission notes that because the environmental site investigation has not yet been completed, the remedial action plan has not been submitted to or approved by DEEP. Whereas the applicant has provided copies of the environmental reporting required to date by the state as to remediation, and has outlined the next steps of the process. Whereas if the site cannot be remediated to residential standards, the proposed housing will not be allowed by the DEEP. Whereas on November 12th, 2024, the fire marshal noted the projects include a high-rise structure requiring emergency power systems. Details for this system have been submitted to the fire department. Whereas on December 5th, 2024, DPW engineering commented that revisions would be required prior to zoning, building, and building permit only. Whereas on October 24th, 2024, the sewer division advised the applicant owner has been working cooperatively and has developed proposed solutions to get their wastewater flow to the large diameter sewer tunnel, and therefore there are no capacity concerns as a result of the proposed development. The sewer division does not have any objection to approval of the proposed project, assuming they satisfy comments from any of the other divisions or departments. The sewer division comments can all be addressed as part of the sewer and building permit phase of the project. Whereas comments from Beta, the Commission's traffic consultant, and DPW's traffic division both indicate the application can be revised prior to zoning and building permit. Whereas on December 10th, 2024, the housing specialist wrote that some of her comments from December 6th, 2024 were addressed. However, she also noted the affordability plan shows the affordability period will start at the start of occupancy and in perpetuity, but the declaration of restrictions shows affordability period to start at issue of CO, and there is no mention of perpetuity. These two documents should be consistent. The sales price calculation shows association fees of both $100 for both 2 and 3 bedrooms. This is a sample calculation, but this amount does not seem reasonable. The matter was discussed with the Affordable Housing Trust Fund Board and Advisory Council that the association fees common charges would be adjusted for the affordable units to ensure their reasonableness throughout the restriction period. The applicant should collaborate with the housing analyst to provide such language. Whereas on October 9th, 2024, the Affordable Housing Trust Board approved the issuance of a third conditional commitment letter for the subject project. The board noted the current proposal continues all affordability provisions in perpetuity and allocates the affordable units equally in 2 buildings. Whereas the applicant submitted an energy narrative along with its earlier plans, and EMAC noted on May 24, 2024, that little information on the specific energy efficiency measures has been provided. EMAC encouraged the applicant to maximize the building's energy efficiency, including choosing all electric Energy Star appliances and solar PV to reduce the energy expense burden for inhabitants, especially given the purported affordable housing status being sought. Their words. Whereas the applicant has prepared landscaping plans for both sides of the street, and these include trees in the town's right-of-way. Any action affecting town trees must be approved by the tree warden. Whereas the applicant has submitted a logistics and phasing plan. Whereas the applicant submitted a lighting plan. Whereas the commission notes that the language in the CGS 830G housing appeals statute is silent as to commercial uses and the zoning standards therefore. It is further noted that case law provides guidance in this regard. In his decision on 65 Marsh Hill Road, Judge Berger wrote, "Nevertheless, there is a difference between types of applications versus type of uses. The legislative history indicates that the legislature intended to accomplish the goal of encouraging and facilitating affordable housing throughout the state by creating specific legislation that affects only affordable housing applications and not the overall zoning scheme. Therefore, applications that do not fit into the definition of an affordable housing application are not affected by 830G. Whereas Connecticut General Statutes 8-2G establishes a standard of comparable size and workmanship for affordable housing units. And whereas in the decision regarding Wisniewski versus Berlin Planning and Zoning Commission, Judge Berger noted, this purpose of the size and workmanship requirement was to prohibit a developer from taking advantage of bonus densities and building lesser units. Whereas the application material indicates that affordable units will be considerably smaller than the market units and their locations less desirable. Whereas the applicant has revised the plans to equalize the bathroom number between affordable and market rate units with the same number of bedrooms. Whereas, as a government-assisted development, the affordable units in this project will be priced for residents earning 80% of AMI, $144,000 per year, as compared with 830G set-aside developments for which the affordable units are priced for those earning an average of 70% of SMI, or $85,610 per year. Whereas planning and zoning commissions are enabled to approve 830G applications with modifications which address commission concerns. Whereas in its goal to affirmatively advance affordable housing, the Greenwich Planning and Zoning Commission is committed to equitable inclusion and fairness, and as such, the Commission seeks comparability of market and affordable units. Whereas, as noted above, Judge Berger affirmed in the 65 Marsh Hill case decision that the legislature intended the 830G statute to encourage affordable housing in the state by creating specific legislation that affects only affordable housing applications and not the overall zoning scheme. Whereas the commission thus finds that the 830G statute does not require approval of non-conforming structures which contain commercial uses. Whereas the commission disagrees with the applicant that zoning setbacks can be deemed to pertain to uses as opposed to structures. Therefore, be it resolved that the subject application is hereby approved with the following modifications. 1, affordable units with the same number of bedrooms as market rate units shall have not less than 90% of the average usable square footage of the market rate units. For example, if the average square footage of all 2-bedroom market rate units is 2,000 square feet, then the average square footage of all affordable 2-bedroom units shall be not less than 90% of all the market rate 2-bedroom units, or 1,800 square feet, provided that the square footage of each of the affordable 2-bedroom units is not less than the square footage of the smallest market rate units with the same bedroom number. The same principle and size relationship shall apply to all the different sized bedroom units, including studios, 1-bedroom units, 2-bedroom units, and 3-bedroom units. The penthouse market rate units may be excluded from the calculation of the average size of market rate units. Prior to zoning permit, the applicant shall demonstrate compliance with this requirement. 2, the locations of the affordable units within each of the 2 buildings shall be distributed on a pro rata basis so as to be equally desirable relative to the market rate units. As an example, the rear of the eastern building, which faces the rock wall, may not contain a disproportionate number of affordable units. 3, the bedroom distribution in the affordable versus market rate units shall be the same. That is, if 10% of the market rate units are 3-bedroom, then 10% of the affordable units shall also be 3-bedroom. Prior to permit application, site plans shall be modified to eliminate all commercial uses except those pre-existing on 405 Greenwich Avenue. The common charges shall be agreed with the P&Z housing analyst. If there is not agreement, the applicant shall consult with the P&Z director regarding next steps for resolution of this issue. And any other department and staff comments should be addressed. Outstanding. Do I have a second? And you can stop the share.
Second.
Mr. Lowe has seconded. Would the commission like to discuss this? All right. Let me start out the discussion. I put 90% of the size as an idea. It could be a different percent. The applicant has argued for 70. I felt like 90. I think Mr. Hollister touched on the fact that that may be a number that DOH supports. Not sure. Do you have any concerns with the 90?
No.
Or would you want to see that modified?
No concerns.
Okay.
I don't have
will-
any concerns. You know, it's plus or minus 10% sounds like something that's much more comparable than plus or minus 30%.
Then the other thing that I did, and they touched on it in the discussion today, and I was pleased about that because I felt it was a good idea then. Taking out the penthouse units gives the opportunity to the applicant to have that high profit unit, those big units, and not have to include them in the average. So they get a benefit, at a greater benefit proportionally. They're not forced, you know, if the penthouse is 3,800 square feet, they're not forced to include that in the average. And so that's a nod to them to facilitate. Are you guys all okay with the penthouse units being excluded?
Yes.
Yeah,
Okay.
I am too, for the reason you just stated.
All right. Wow. I thought this, I wasn't sure this would fly. Mr. Hollister said on the record that maybe it was nice to be facing the rock wall. I hadn't thought of it at the time. But I think the point still stands. Evenly distributed, everybody's, you don't put people in the basement and you try to, and we're working again towards, okay, so you guys are okay with the distribution.
I think you're on the right track. I mean, generally speaking, I think the expression is between a rock and a hard place, and that's not a favorable place to be.
Oh, and everybody's comfortable with the complete elimination then of the commercial.
I don't see how it fits.
Yeah, we don't have an option.
Yeski?
Yeah, no, I don't think it was the
All right.
intent. You got to give them some credit for coming as far, as they've got into this. It started out as a rich, poor building. They're getting a lot closer, but it's still unacceptable.
Okay, so with these modifications, hopefully it will work. I struggled with the common charges. There's no state statute. There's nothing that makes them fair. The Fair Rent Commission doesn't really address it. Patrick looked into it for me yesterday, was it? So I was trying to figure out if there was a way to make sure they were reasonable. We're just gonna try and work it out and see if we can find some other precedent in the state. So we've had a second from Mr. Lowe and Mr. Yeski. How do you vote?
I agree. Yes.
Is an aye.
Aye.
Mr. Wells,
Aye.
Mr. Lowe,
Aye.
aye. Mr. McRae.
Nay.
Mr. McRae is a nay. And Albin is an aye. And with that, the motion passes 4-1. Wow, I thought we were going to be talking about this for hours, so I'm glad.
We were.
All right.
We have been.
So with that,
Well, I
we-
guess the question, is there any modification, Mr. Macri, that would turn your nay to an A?
I'm finding that actually that the application, in my opinion, is actually incomplete for a detailed review. I'm not confident in making a decision on this project. I believe there's a lot of outstanding issues that go directly to health and safety. The residents have spoken, and their representation of people who actually live at the site not the studies, not the engineers. People who live there are telling us a different story. This project is way too significant not to kind of lightly kind of review things. And I'm finding that there are a lot of promises, unresolved issues, light answers, or not even a good answer to some of the questions and issues that we had. And I think some of the things that we had talked about actually needed to be specifically resolved prior to any kind of decision at all. In the non-conformancies, we can go on and on and on. Beating the horse to death here. So, but in my opinion, is basically the application was completely missing it. There was a lot of information that we needed to have. We asked for it, and it came back without any thought or detail to it. So,
Yeah, thank you.
Okay. Anybody else? Any last comments? Okay, so we now move on.
Yeah, Ms. Culp, you can sign off. We're out.
Kelly, thank you as ever. We appreciate your patience, and I hope I didn't read too fast, but we can send you the document.
Can't hear me, but okay, thank you. Have a good night. It's all good.
Bye-bye. Oh, wait, we won't see you again. Happy holidays, and
Happy
wishing
holidays,
you
Merry Christmas, everybody. Yeah.
all wonderful things next year.
You too. Thank you. Happy New Year.
So the next item is I'd like to make a motion that we postpone item 3C and not do this tonight and do it at a future time. And the reason for making this motion is that the DPW still has some issues with this application. Since they can advise us once they're resolved, I believe it would be better if we postponed deciding Havemeyer tonight. Do I have a second?
Second.
All in favor?
Aye.
Aye. Okay, and now we go to our next discussion item, which is the Bruce Museum Steamboat Road pathway, and then we'll talk about the budget. Just to ask you guys, we can finish probably by 7:30 or so. Do you guys want to take a quick 5-minute break before we do the discussion items?
no, I think I'd like to get all the way through.
5 minutes.
I would be happy
5
to
minutes.
grant a 5-minute break.
I just need 5 minutes.
For,
even less. Just
for
give me a second.
biological reasons.
For biological reasons.
Second.
All in favor?
Aye. 5 minutes.
All right. Can you hear me okay, Tracy? Okay. Yeah, it's just, I think I finally
Yes.
figured out how to do the settings. Believe it or not, it does better if it's on automatic.
Oh,
Man, I hate reading those 5-page motions and I don't mind writing them. You know, I fool with them all weekend, but God, I hate that whole out loud reading. And then then I make mistakes and all right.
It's all
Okay.
good. It's all
All
good.
good. We're here.
Good. We're here. They got it. They could see it on the screen too, so it's fine.
Mm-hmm. Hey, I beat everybody back. I had like 8 glasses of water. I'm really sorry. Much information. Sorry. Okay, Madam Cronin. Well, we'll wait. We need Dennis. Dennis and Mary Jenkins and Peter Lowe, Dennis Yeski. Dennis has to come back. Is his 5 minutes up yet?
3 minutes and 45 seconds, Madam Chair.
Only 3 minutes and 45. Seemed like longer.
I said a stopwatch.
Let's get it happening. I was supposed to be at a Christmas party a long time ago.
Well, except that I happen to know that you want to opine on the Bruce. Okay, we've lost Peter Lowe. I'll start reading it. Oh, all I need to say is discussion item. Bruce Museum Steamboat Road Pathway Landscaping and Lighting Plan.
I'm here.
Okay, go ahead, Michelle. Ms. Cronin.
Hi, everyone. Michelle Cronin for the record. Thank you guys so much for squeezing us in your last meeting of the year. So Eric's going to kind of take the lead on this. He actually has the reins on the presentation. So I did start our images with the existing or the approved landscape plan. I think you were saying at the briefing, maybe Nick and or Mr. Macri and Ms. Albin, you guys were around when we got this approved back in 2017. So this is the approved path. I only colored.
Dennis, you were as well, weren't you?
I was, yeah.
No, Dennis.
No, I
Oh,
was
Dennis.
here. I was here.
Yeah, Dennis was too. Yeah, so it's not too bad. Go ahead.
Yeah, so I colored up part of the path, just kind of what I thought you guys would be interested in looking at. So this was what was approved. And then the next image is the as-built to date. So we've kind of done everything on the east side of the site. And we took that front path down to Museum Drive, and the stairs have been redone, but obviously that steamboat pathway has not been built yet. And that's where we brought Eric in to sort of look at that and help us construct that. And he's brought some issues to our attention, and that's what we wanted to talk to you guys about and sort of our next step forward on that. So Eric, do you want to just kind of go through your findings and we can go from there?
Sure. Good evening, everyone. Thank you for making some time for us this evening. So as we started looking at the proposed configuration, the first thing we figured we should do is understand the slope. And so we did a slope analysis. And what we found is that the red hatch zone is at a pitch that is, it's a 50% pitch. So it's a 2%, I mean, it's a 2-to-1 slope, which is a pretty substantial slope. And we overlaid the pathway on it to see, how much of the path would be, in the zone, and you could see the portion of it, the center portion of the path that is within that steep slope of the site. And so as we contemplated, what that means, we discussed the constructability of it, and then went to the next step with a a more detailed grading plan of the same the same layout in order to know, in order to understand, if it's built in its current configuration, how do we get from elevation, I think it's 25 over here, to elevation 47 here, and what does that look like? What we found is that as you step off of the existing walkway at the top of the base stair, you're immediately on an 8% incline, which is the maximum slope of an ADA ramp, just for reference. And then it gets you to a set of steps that have been shown to another 8.3% slope to another set of steps. And when we get into this zone, which if you keep in mind that we're right in here, right in the middle of the 2-to-1 slope area. When you get there, what we found was, in order to create the level zone to walk on, we would have to introduce a retaining wall to hold the slope back, and then another retaining wall on the downhill side to level out the slope below. And that would happen up these sets of stairs across here, and then that puts us into this vicinity, which is you're on grade, you're back on grade here, and crossing an easement, a utility easement that comes from Steamboat up through the site, and then as you're sort of parallel to the slopes at that point, and then when you get here, you're back on an 8% slope area to steps, and this is sort of the high point. You start going back down again at 8%, and then there's around this ledge. So what concerned us about that is that at an 8, anything above 5% has to have it's treated as a ramp. So that would mean on both sides of the path, as soon as you step off, would be handrails on both sides up to the steps, which due to the quantity would also have handrails on both sides, and then continue that onto this section, double handrails here, double handrails on the steps. Then on the downhill side would be a guardrail that goes across here, and then double handrails again up to the high point here, which this little section probably wouldn't have to have handrails, but then back to double handrails all the way over to the service drive. So all of this started telling us, is the experience of utilizing the path really going to be and do, what it could be? And so, we sort of filed that away and then went back to the constructability. So these lines show the proposed grading that would have to occur in order for this to be constructed. And then the red dash line here is what we're calling the construction envelope, because in order to build something like a retaining wall, as you excavate, there has to be a slope to the edge of the excavation just to hold it in
Mr.
place.
Rains, Mr.
Yes.
Rains, Dennis Yeski would like to ask you a question.
Oh, certainly.
Yeah, this isn't going to be ADA compliant, right?
Well, the 8% is, but it does have steps in it.
Right.
So,
that's what I'm saying. It's not ADA compliant, right? You're not getting around the steps. You're not doing a ramp around the steps, are you?
no, we're not.
Okay.
So the ADA, the being above 5% kicks in the requirement for the handrails on both sides. Even though, because it's still
I get that. It's just some way I thought, did we require ADA compliant, or is it required?
Yeah.
Well,
Yeah.
it was always approved with stairs. So it was never going to be ADA compliant. The 2017 one had stairs as well.
Eric, sorry, Dennis, Mr. Yeski, it's a good question, and I'll just go back. If we go back to the circle walkway on the upper level, I think it's your first image.
Here.
The purple ribbon from the is it the southernmost or it's the westernmost driveway was presented to us at being at grade going east. And that was the discussion we had in the beginning, that this followed basically the same elevation and was essentially flat grade, even though it meandered. The stairwells and everything else on the hillside, that was not going to be ADA compliance. The ADA compliance is from the street to the front door.
Got it.
So this doesn't put them out of compliance, but it also was not considered to be a ramp that would meet those grades if installed. So I think I think everyone's remembering parts of the discussion, and this part had stairs.
So we didn't require ADA compliance, and it's not required.
It's not required. We didn't require it, and I believe, if my recollection is correct, is the commission understood, or it was explained to them then that it was not going to be the main entrance of the.
You have to offer an ADA compliant access, but
Right.
it doesn't have to be, all accesses don't have to be ADA compliant. That's
Right,
really
you
what
have to
you're
have
asking.
a access point, not all access points, and that was the discussion, and it was not a condition of the approval.
Yeah, I just assume ADA means you go down Steamboat, you turn up museum, and you go in the main entrance, and that's ADA. Got it.
Yeah, and there is good access from the sidewalk, Mr. Yeski, that is accessible, but it's not this path. That's not the main entrance.
Right. I was just going to say it's crazy. Never mind. I answered the question. Got it.
Yep. And then what was your second question?
Oh, sorry.
I didn't have a second one.
Oh, I thought there was two. I'm so sorry. Go ahead.
So another component of it that we began to evaluate is, the actual constructability of it. So the red dashed line represents what we're calling the construction envelope, which means that, something like for this wall, excavation would happen starting back here. And then as the wall went up, you would backfill behind it as you go to establish the new grade. And then we enclose the limits of proposed grading in this envelope, because that's where the grade is going to be changed. And what we noticed right away is that, potentially and most likely 5 of the trees would be affected. Their root zones would be, significantly impacted. And so what that would mean is the potential and likely loss of those trees, which is sort of right in the middle of the slope area. And so as you get farther up, it gets a little easier because you're closer to existing grade. But we felt the impact of the construction envelope would be something that we should share with you all, just to help describe the sort of the process that we have been going through. And so on this one, one of the points that had been made, I think in your briefing, was getting to the front door. And we did just a simple calculation and laid out the walkways. What we found is that the red is according to the proposed path, and it's 704 feet, if I'm reading that right.
Okay.
704 feet from the base of the existing stair. And then just for comparison's sake, we went down Steamboat, up Museum Drive, and then up the walkway along the driveway, the main driveway, to the front door. And that one is 921 feet. So those are the two dimensions. We talked about, what happens if somebody uses, sorry for all the jumping around. What if somebody uses this, but we didn't go very far with it, because at the top, it puts the pedestrian in the vehicular route. So we didn't think that merging those two uses would be a good thing from a safety perspective. So the next slide is just for reference. looking, if you've been there lately, you've seen that there's been a tremendous amount of cleanup. So here's some of the trees that would be lost in sort of in the middle here. And it's that 2-to-1 slope that that I've been mentioning. And similarly, these would be the trees that would go. And then the same thing over here. When I saw this photo, when I took it, it didn't cross my mind, but when I opened it on the computer, you know, what struck me was, you know, how do you stage a piece of equipment on that to even do the excavation? And the complications, you know, of that. So again, it speaks to what we're describing as just the, you know, the real constructability of the path. And then another exhibit is what was anticipated for the boardwalk section was that it would be about 30 inches above an existing grade. But when we measure the grade line here, it actually represents a 3-to-1 slope. And so we overlaid a 2-to-1 slope to give you a sense of how it would affect this. So you go from around 30 inches to upwards of 4 feet. And this would be the view from Steamboat looking up. So with 4 feet up to the underside of the boardwalk, that would be the view from Steamboat. So, and then the other component that this highlights is the footings have to get, you know, much deeper. A structural engineer would have to tell us how far below finished grade do you have to go in order to get enough soil resistance on the downhill side. And currently they're shown at 4 feet deep, but they, you know, I'm not a structural engineer, but my hunch is that these would potentially grow to 6 feet deep or so, and be sunk deeper below the grade so that you have the resistance on the downhill side. So from there, we started talking about, you know, and I know that this is what we're hopeful that you'll see and hopefully agree with is that it would be worth considering other ways to provide a meaningful experience to get from Railroad Avenue and Greenwich Avenue down Steamboat and to the museum and to the harbor, or even if you're going to walk all the way out to the end of Indian Harbor to see the water there. If you would agree that it would be okay for us to study other ways to provide a quality experience to get to those locations and at the same time over to the door of the museum. Yes, Mr. Lowe.
Thank you, Mr. Rains. I was just going to tell you. Go ahead, Mr. Lowe.
Oh, going back to that for a moment, I hope I've been following this carefully, but there's that stairway down where you can see a pedestrian. I think that's where there's a stair on this site, but there, in any event, there is a almost direct route that you showed going upstairs, up the hill, that empties somebody onto the roadway, which I recognize that it is not totally desirable, but could you install some sort of striped walkway and a stop sign at the top of that sort of shortcut up to the driveway to serve as an optional access way, obviously not ADA compliant, or ADA accessible, but just as an option.
That is there right now, Mr. Lowe.
Okay, but would there be appropriate signage? It's all there. So, right, are people using that to gain access to?
To be honest, I'm not sure how many people actually use it. What used to be the front door where they kind of drop you off. Yeah, thank you, Eric. Is really the main drop off for school buses, So that's where the kids come in when they have field trips at the museum.
And it now feels like the back, right?
I mean, it's nice, but yes, it's not the front door anymore.
Yep.
So it's somehow less desirable or something. All right. Anyway, okay.
Mr. Macra, then Mr. Yeski.
Yes, can we go back to the original approved plan? I think Mr. Lowe brought up an interesting point. The front of the building is now the back of the building. And I think we kind of realized that when we were reviewing this back in 2000, I don't know what, 1,000 years ago. Can you zoom in a little bit closer on that? I know, and I remember distinctly this commission and the ARC agonizing about what was going to happen on this particular aspect of the property. Understanding that the front door is now under Museum Drive, and it's basically turning its back onto Steamboat Road, and the connectivity between Greenwich Avenue and the front door. I think actually looking at this, I don't see any kind of significant differences in the way that the path moves up the site. I think actually understanding it's moving across the slopes, not generally up the slopes, and your regrading is significant. But just because it's going to be difficult to construct really shouldn't be an issue. The issue is this side of the building, this portion of the property needs to be really relating to the rest of the town. I think we really stated that very clearly when the application was reviewed, both by this commission and ARC. And I think actually as part of that, we were expecting this to happen this way. Even to the effect actually heavy duty landscaping, the pathway, meandering through what would have been public art installations, and really reclaiming this kind of backyard issue. It's still, again, connecting the bottom of Greenwich Avenue up the pathway to the front door of the building. If it's difficult to construct, maybe we need to be a little bit more clever about how we go about that. But I don't believe that really we should be kind of changing any of this. We've approved it, and we've approved it for specific reasons. I think the landscape plan here, you need to cut some trees down, but this plan shows actually a lot of trees being planted. I mean, what's the difference between what you have or what you're proposing and the landscape plan here? Is it significantly different? I think the railings issue is an opportunity as an art installation. You're going to require ADA or handrails for the stairs, for the pathways, for those things. Maybe that becomes part of the art of the pathway. I think if you're looking at alternates, it's got to follow this, or generally follow this route. If you're looking at actually constructability, I think it's actually understanding what is the end result, how to go about it. And if it's, okay, I've got to redo grades, I've got my retaining walls, figure that into as art installations or something that's attractive. So when you're coming off of 95, you're coming down Steamboat Road, you're heading to the museum, this is part and parcel to that. It's not just the leftover backyard. It's in so many words. And I remember distinctly hearing a lot of people say this is the front yard. Thank you.
Mr. Yeski, Mr. Wells, and Madam Jenkins, and Mr. Lowe. Mr. Yeski, you go.
Right. I mean, I agree with Nick. I remember thinking about how difficult it was going to be, but the idea was to kind of make it an experience unto itself and connect it downtown. But I guess my other question is, do you have other, I think you're asking our ideas and we're giving it, but do you have other thoughts on connecting it to downtown?
Well, we're the, oh, sorry. Do you want me to?
No,
Yeah.
that's it.
Yes, please do answer.
There's a couple of things. We're the landscape architects for the railroad, a Railroad Avenue project with Ashford. And
Okay. Right around the corner, right?
And part of that project on the corner of Steamboat and Railroad is a footing that's being installed that hopefully would be a place for the museum to take advantage of with a rotating sculpture program.
Oh, good, because we've been asking and asking and asking the museum to work with the Ashfords, and we had not known that there was any headway. I've written both parties.
Mr. Ranch, can you say that again? I don't think I understood that. You're putting a footing in on the other side of the railroad bridge and the highway overpass for rotating art installation.
Sculptures.
Sculpture that,
Okay.
that would represent the Bruce.
Well, how does that relate to what we're looking at here?
He's just saying, hey, we've already got an exhibit opportunity.
That's
But
great.
We're
That's
asking
great.
you,
More,
right,
the
but
more
we
the
want more.
better. So
there you go. The more the
this
better.
is nowhere near that. It's
Yeah.
connection from that to the museum, but not that.
Right. Another component that we put together and presented related to that project was a wayfinding possibility.
Right.
And that's no longer part of that project, but we have, I can show you what we put together and presented related to that. So here's the corner of Steamboat here and Railroad here. Here's the sculpture base. And then the thought was that we use the elastomeric product that's used for crosswalks and assign a color. This is just a concept, but assign a color, list the destination and have it connect from Railroad Avenue, not only to the museum, but also to the harbor and to Roger Sherman Baldwin Park. And so we put these images together to see what that kind of application could look like. We introduced a crosswalk here to get over to the steps that are the existing steps that lead up to the Bruce. And then as you move farther down, in this concept, yellow is the Bruce. So you cross here and go up Museum Drive. You go on the blue down the side of the harbor. There's a public access down past the Delamar, or you take the green over to Roger Sherman Baldwin Park. So, these are just a concept, but they all started, the whole thing started at Railroad Avenue and Steamboat.
Got it. But did you have any other thoughts about?
Go back to the museum now. And
Right.
what we're saying to you is, let's stay on this site plan. That was next point. And let's stay on this site plan. And then after that, Dennis, did you want to say something else?
No, that's what I was saying.
Yeah.
Good, that wayfaring, but do you have any other ideas about the path or anything else?
Not about the path, but about a quality experience at a sidewalk level.
Yeah, but we, again, okay, so let's just hear from everybody. Arn, then Mary, then Peter Lowe. I'm sorry, it's just Peter now.
Yeah, could we just go back to not this, that, yeah. So I think everyone knows this, but the Bruce for the last 20 years, even before this expansion, the main entrance was not facing Steamboat, but you see it right now to the right of that. That's not the main entrance. Go right there. That's been the main entrance. So that's where it is, or has been. Right now, if you come up those stairs, you can't even get in that entrance unless you're bringing a child for a program or unless you're a docent. So everyone has to go through the main entrance down on Museum Drive. I think I'm very concerned about the current proposed path, and I don't think you get much of a benefit. You're saving 117 feet by doing it. You're doing massive disturbance. You're putting in retaining walls. You're going to have to start worrying about drainage. You've got existing trees. You're not going to be, those are big trees you're taking out. You're not going to be putting in trees anywhere near the size. And as we know, trees absorb water and reduce flooding. But kind of what can we do? So I'm saying putting a path in there as proposed would not meet any of our sustainability objectives. But what can we do? I mean, I sort of like it the way it is. Natural. Let's improve the landscaping there. So when you're walking down in the fall, maybe you see red maples. Maybe in the spring you see cherry trees. You're coming from downtown, which is distinctly urban. Let's give them something different and give them a beautiful landscape. The other thing we could do, and maybe this is crazy, you're walking underneath two really ugly tunnels. Maybe the Bruce could commission someone on one of those tunnels, the I-95, to do, you know, a mock-up of a Connecticut Impressionist painting. Something's better than this to sort of bring you along. Then you have, you know, a beautiful landscaped hill, and you make your turn. But to tear apart this hill, to somehow tie it into the business district, really does not seem to be worth it, the way I look at it. Thank you.
Okay, then Mary, then Peter Lowe, and then Ann Knoll.
Yeah, I mean, I agree completely with Arn. I don't think that people wander around looking for the entrance to a museum often enough to justify retaining walls and handrails, and that there are beautiful trees there. That intersection, that four-way intersection right there, it's already got parking lot on one side, hotel parking lot on another, insurance building parking lot on another, and now we're going to put handrails and retaining walls and things. If we want people to wander, that's not going to be a particularly attractive place. And I really like Arn. I hate to see one of the few little green areas at that intersection right by the museum. And again, even when the entrance was where it used to be before the addition to the museum, that was an awkward place, and people didn't use it a lot because it was steep. And you know, I would rather see almost a little electric car shuttle between the train station and the Bruce Museum, or between the train station and the playground across from the Bruce Museum, than pull up, you know, 6 or 8 mature trees and change a green area into something else. I would prefer to leave that as natural as possible and find some other way to get people to the front entrance of the building.
Peter Lowe?
Yeah,
Ann Knoll?
I agree. I think, you know, this isn't a situation of if you build it, they will come. If you tear down a bunch of trees and put something in there that people don't use, it's not a good thing. Unfortunately, as constructed, the quote new museum over many years, the design seems to be a deterrent to creating some seamless connection to the museum from Greenwich Avenue, which is what this vision that people are trying to produce. And we're kind of struggling, it seems to me, with trying to provide an answer to a potential non-problem. I mean, the problem is the sort of the angles, the geography, and the topography. So we have to deal with what the cards that were dealt to us. And right now, it's a museum that fronts on the other side of Greenwich Avenue, just diametrically opposed, and adding a lengthy and arguably laborious path that is wreaking destruction and the like on the natural environment. That may not be the right way to go.
Okay. And no.
Thank you. So I agree with the others who've said that we don't want to destroy this little bit of green here to build this path with railings and retaining walls and all of this. I'm trying to think, how do we, I still really love the concept of trying to draw people from the sort of Greenwich Avenue, the retail side of things underneath those bridges over to the museum. I must say, I have never gone to the museum from walking down Greenwich Avenue. I typically go when I park there when I go, but I think that idea of trying to sort of figuring out ways to I don't know whether it's those lines or whether there's sort of other artwork or sort of little creative signs or things that you can do to pull people into the museum. And also, I agree with Arn that is there a way to make walking under those bridges a little bit more pleasant? I think that would help to sort of bring people, because I feel like you sort of stop there, unless you're trying to go to the train station or a parking lot. So I agree with that. It's a thorny issue. And how do we accomplish what we hope to accomplish without destroying this parcel?
There you go. Mr. McRae.
Mr. Raines, can you zoom in really close on the proposed path? It's my understanding this is the approved landscape plan.
This is, yes. You want to
Okay,
zoom
yes.
in on this one?
Yes, zoom in on this one right on top of it, so a really good sense of the landscape. So as approved, we were really going to reclaim this area to be a benefit to the town. Understanding that it's left to natural state and gets cut once in a while, that kind of thing. But understanding the connectivity between Greenwich Avenue and the front door of the building. I think like I said before, we kind of agonized about what was going on here and wanted to make sure that this was going to be the best thing that it could possibly be. Understanding right now it's the backyard that's been neglected. It's a leftover. What could we do to make this, which is actually a kind of a gateway to Greenwich, the best it can be? And I think this landscape plan goes up through it. We're adding trees. We're adding other issues, things here that actually make this a pleasant experience from one point to the other. If we left it in its natural state, it's just a natural thing, and we still have, no connectivity, and we're still looking at the backyard of the building as opposed to what really probably should have been the front yard of the building. Mm-hmm. I think if Mr. Raines is coming back with alternate ideas, it's still got to be point A to point B, and being clever about how to construct it if that's the biggest issue. That idea of actually having a boardwalk on piers, was a clever idea over the utility easement, because it actually gives some kind of a visual interest to the walkway itself. It's something that's not seen so much. Maybe that's it. Maybe it can be, a different material or a different way of doing things. Maybe the walls behind them actually have art. Maybe the walls in front have art.
So,
but I think we have to understand this is actually a significant portion of the town, and that we need to actually kind of look at this to say, is it just the backyard, or is it really should be the front yard that the whole town and everybody coming to this traffic light and passing under those bridge really can enjoy?
And no.
So, all right, one of the things I forgot to mention was I'm wondering if there's a way that we could do sort of, I know there's a steep slope here, but kind of do a more natural path through this, or sort of think about that. And some of that might be some of the, like the piers that Nick was just talking about. And I think about walking through someplace, like some of the gardens around town that open up periodically for people to go see and stuff, and how it's a really pleasant experience to wander through those, but without completely destroying what's there, and somehow enhancing what is there, and as I said, keeping it kind of maintained.
Ms. Cronin, was that a question?
No, it was just a thought.
Statement of desire. Okay.
Trying to throw out ideas about kind of what we could do to make this connection work here.
I believe, just to clarify for you folks, I believe that the applicant is asking us for agreement to proceed with different types of designs. So we're able to get there. They were open to new ideas. That's what they're asking for. Michelle.
So I'm just a lowly planner here, not a landscape architect, but the thing that I was kind of pushing for, and what I wanted to talk to you about, Eric, can you just go to your sketch? Obviously Eric and I both worked on the Greenwich Plaza project. So what he had started to say is at that corner, there is an opportunity for a piece of art. But then as you go down, you know, the town has done such nice work to the sidewalks along Greenwich Avenue. And so my thought was to continue that, to continue what the sidewalk's going to look like in front of the Greenwich train station, where we have the trees, we have the same lamps that are on Greenwich Avenue. And if we can redo the retaining wall that's along that sidewalk now, in the image that we have from Google Earth, like that sidewalk is so narrow. So we could basically double the size of the sidewalk that's there now. And we'd have to redo this wall. And I talked to Eric about potentially reusing the materials there, so you still get that feel from, you know, the original museum building. But if we could grade that slope, you know, that wall would be much lower, the sidewalk would be wider. And if it was flat enough behind the wall, we might even be able to put some art there. So you have art on the side, you have a bigger sidewalk, you have sidewalk trees, you have the lighting. You know, we could talk to, I think the issue with the mural, which I actually really like that idea of putting a mural under the overpass, we would just have to coordinate that with ConnDOT and see if, you know, we'd be able to do that, because that's their property. But I agree with the POCD, and I think that we need to draw people down, but I don't know if that path that was approved is really going to do that. And to me, I think something at the street level, at the sidewalk level, is going to pull people down more. You know, maybe putting that crosswalk in that Eric showed. So you're doing all of Greenwich Plaza has new landscaping on the office building side. So then you have a nice crosswalk that crosses you over to this side. And this can be activated, I think, a little bit better. So that's sort of what I was pushing for, and that's what I personally wanted to talk to you guys about, because if you're like, no way, we absolutely want a path on that hill, you know, then we're going to have to continue to look at that.
So,
and just for reference, the existing sidewalk is in the sketch is this dashed line.
yeah, we saw it. Mary?
Yeah, I absolutely love this idea, because you're, with all due respect, that side of the museum building is not something that you necessarily go, oh, I really want to walk closer to that. This would be, I should think, a lot easier for people with children or people in wheelchairs. And also it's like a path toward the water. So I really like this approach as against disturbing the existing green slope and putting something there. I think this is a great idea. I really like this a lot.
Mr. McRae, Nick, and then Arn again.
How is this not regrading the slope up above? We're going to remove the tall stone wall, make it lower, push it back. You're going to have to regrade the slope up above to make the sidewalk wider. And then when you get to the corner and you go up Museum Drive, the same width of sidewalk is there. You're going to do that one too. I mean, they think this is the kind of thing you got to think this through. And you know, what was the original intent, and stay with that.
So should I respond?
Well, hold on, okay. Let's just get Arn, and then you can respond, because you're hearing some differing input. We're going to have to put it together.
Okay.
Yeah.
Go ahead.
Yeah,
Arn.
I mean, briefly, I had the advantage that I wasn't part of the original intent, so maybe I can look at it new.
And
But
in full
I really
disclosure,
like,
you have an
Sorry?
intimate relationship of this campus.
yeah, but we don't have
Yeah.
to push that. But
No.
I like the sidewalk idea. Additionally, maybe some signage up on Greenwich Avenue so people know where to go. Maybe some signage in the train station. And then my last point, one reason I'm so passionate about not disturbing that slope is the Bruce originally sat up on top of the hill. That's where Mr. Bruce built his house and then expanded. But the expansions were on top of the hill. This latest expansion, you've dug into half the hill. You've had to remove massive amounts of ledge, which you guys know that you approved it, but you basically cut the hill in half in order to do the expansion. So I personally think we've tortured this land enough. We've expanded the parking lot significantly on the backside. We've added to impervious surface. And the last thing we need is more impervious surface with a path going up. We haven't even talked about that path crosses an active driveway where you've got school buses coming down and also delivery trucks coming down, some of which have to back into the loading dock. So it's the path, it's not
very nice up there.
It's not very nice up there. It doesn't look that nice up there unless you like looking at a loading dock. And there's also a safety issue in terms of crossing that active exit driveway. Thank you.
So what I'm hearing is mostly openness to a revised plan, a revised concept, with some reluctance from Mr. McRae, support for what we will call the Cronin sidewalk. And the only thing is, since this is a special permit, we'd want you, I think, to come back to us with what you conclude as the best approach. You know our priorities. We wanted the connection to the museum. We are uncomfortable with a lot of regrading, cut and fill. We definitely want to save as many trees as we can. I think we're all kind of loving the idea of adding street trees. I think I'm just guessing that if you have an area to exhibit art, you might end up having to regrade some more by the Cronin sidewalk. So let's maybe not do that if it makes more regrading. That's what I'm hearing in summary. Patrick, you wanted to jump in?
Yeah, you said special permit, Madam Chair. I'm not sure this needs a special permit.
No, it was a special permit. Well, there's changing
What?
a
No,
site plan.
you said, oh, sorry, if that's what you said, that's absolutely correct.
Yeah, they're changing a special permit and an approved site plan. And what I'm saying is, I'm hearing enough passion here that we'd like to keep our little fingers in this pie.
And my only suggestion would be if there's a diversion from the original plan, or there's three options. There's no more work and we'll just stop where it is right now if the commission agreed to it. I'm not saying they are. A revision, and I think that would probably be a site plan only because there's no building here, right? It's site work only. And then if there's the execution of the original, which is just continuation. So I don't think we need to go.
Right.
I think the commission can be involved under that process, but
yeah, all I'm saying is
be an exceptional.
No, my point was, even if you could have totally approved this on your own, I think I'm hearing that the commission would like to keep itself involved in this because there's a lot of strong sentiment around the Bruce. It's an important town institution. We want it to be beautiful. We want to connect it to downtown. So we'd like to see that. I think, am I correct in reading the room that mostly we're open to them coming back with an additional idea, and maybe even just as a discussion item to save you guys time, just come back with, flesh out your idea and just come back with it. Tell us how you're going to reduce the regrade, how you're going to reduce the tree removal, show us this concept that's here fleshed out, and just do it as another discussion item. And then we could pop it on an agenda whatever way works best that Patrick thinks works best to be efficient. I don't want to turn this into a big production, but I know we want to be involved. Patrick, does that work?
No, that's fine.
Okay, Mr. Lowe.
No, I was just saying, looking at this particular depiction, it almost looks like there's an opportunity there, having regraded it, to create some sort of artistic shelf along that.
That's what she suggested, and I said, hey, but before you do that, make sure it doesn't require even more regrading, because we're kind of done with people tearing up the planet all the time.
I think it's a little flatter down.
Yeah.
Down there. That's why I suggested it. But
right. No, I'm in support of that, and I apologize for not picking up on it when you offered it originally.
No, absolutely not, because it really goes to Nick's question too, which I think Eric was probably going to try to respond to about pushing that wall back. Because it is a little flatter, and then you kind of, the slope goes up pretty drastically.
But it's a little bit like, sprinkling the breadcrumbs along to
Right.
pull people along. Yeah. Anyway.
Okay, is that kind of a consensus? I know, Nick, you're hesitating. I think, Nick, I heard you leaning to just keeping the original path.
I think Mr. Reigns has to look at a couple of different options and bring
Okay.
those, all of the options in. Let's take a
Perfect.
look. But
Okay.
I think actually, getting back to what I originally said, we had talked about this particular aspect of this particular project years ago, and it was something that was very important to both this commission and the ARC at the time.
Yes.
And it's still a critical issue because of where this piece of our property is, this part of the property is, and its relationship to the gateway to Greenwich and the bottom of Greenwich Avenue.
Yes. Okay, so bearing in mind, once again, what our priorities are, and boy, we're good at articulating them sometimes, and Nick has just restated them again. Yeah, we're open to hear what ideas you have.
Mr. Reigns, I have a quick question. Could you bring your presentation back up real quick? I just want to make sure I understand something.
Yes. Yes, you can see that.
The photos of the existing conditions. When was that taken?
3 weeks ago.
Okay, so all of the undergrowth that was out there is gone, and it's just
It
the mature
is.
trees that are left.
Exactly. We've been working with the tree warden to get all the invasives cleaned out, and so that's what's been accomplished so far. And the next step would be what we're talking about now.
Okay, thank you very much.
Which includes planting, like you mentioned.
Thank you.
Okay, so we good?
Yep.
All right.
Well, thank you.
Thank you. Thank you. Thank you for making the
you.
time.
Have a-
Very interesting.
You too. Have a great holiday.
You too.
See you in the new year.
Thanks, everybody.
Bye-bye.
Thank you.
Bye.
Okay, now we're gonna do the budget. Are you ready to share with us? Because you know how we all love Excels.
Oh Lord, you want me to post the numbers here? Okay, I could do
Oh, wait.
That's-
Is it confidential and you don't want to put it in?
I don't think. I mean, there's gross numbers here. I mean, this is all going to be public if approved, but
But
I
the
thought we were gonna
BG
talk about
doesn't have it.
fees.
Okay, let's talk about fees and then okay, on the budget.
Yeah. Well, I can go to that if you want to talk about that first. That's
Why not? Or if we
Okay,
have,
go ahead.
if you have some hesitation about it, and we
Yeah.
don't want to invite more participants into the discussion
Did you hear that, Rob Marchand?
on our budget.
well. I mean, listen. I said this yesterday at the briefing. Our budget is not incredibly complicated. It's it's every line has a purpose, and the budget guidelines. There is a 3% growth cap on our salaries, our fixed costs, and then a 2.75 growth on the operational side. We are a flat budget on the operational side. We're not looking. I'm not proposing to increase anything or make big expenditures. Our budget is tracked with the costs that we accumulate over the year, and we're good there. Salaries are going up as contractually obligated. So most of the employees in the department are union, and so they have contracts, and those contracts have escalators every year, and so that is where the growth is in the budget. It is right around 3%. It's a little bit over by a few hair shaves of a point, and that's just the numbers and nothing nothing fabulous.
Yeah,
or
but you've convinced me. Rather than have this sort of group thought on line by line items, I think it would be more instructive for each of us to take a look at this and figure out what our own approach would be or attitude without, because look, it's like getting an application cold.
The only thing
Yeah.
is, I believe we have to make a motion. And we have to make it before the end of the year.
Right.
So in general terms, we are comfortable. We know we'd like to, we know that we're not clear on what's going to happen with our consulting fees versus, for example.
Well,
when
yeah,
we-
let me touch on that, Madam Chair, for a second. So,
Mhm.
first of all, this is for the budget that starts in July of 2025. So this is 8 months or 7 months out now, or actually no, 6 months out. So we're under the current budget now. There's money in there to do things like the consulting and the studies and things like that in the first half of the calendar year, second half of the fiscal year, and then we have the money built in again to continue those studies or do more studies in the following fiscal year. So we have the opportunity, and we're going to maintain that level that we have had for the past it's probably 4 years now, right, since the POCD work post plan work has been in play. The only I won't go into a lot of this stuff, but that's the general idea. We are looking to extend the hours on the zoning enforcement side for our part-time zoning inspector to full-time to address the inefficiencies and deficiencies in the workflow there. Otherwise, there's no head count in total. We're same number of employees proposed today as there is tomorrow.
Well, yeah, and at some point we would like to ask for, we will, as always, ask for another zoning enforcement person, right?
We are asking for full-time equivalent this year.
Right. And you don't want to, in addition, so in addition to converting Nancy's job from half to full, you don't want to ask for another person at this point.
It is, we have talked with the town manager, and it's probably not in the budget for 2 people, but 1 full-time is possible.
So what I would then suggest is that when Patrick presents the budget, that we just mention again at that time that we haven't included it in the budget, but that we again do feel that additional enforcement would be very helpful to maintaining the unique, what was it that she said?
I wrote it down, and I've already moved on from that page here. So
Yeah. So the unique characteristics, was it? No, flavor, something like that of the town. But it's important because the violations damage people's quality of life. I mean, you heard even from the public comments tonight, if we can't get out there and look at violations, and some of those are for noise, which we can't do anything about. But yeah, so how about we just raise it again and say, hey, again, we're not asking because we know the town's tight for money, but we sure would like it if you have any extra bucks lying around. What else, Patrick?
the only other thing I wanted to talk about, which I'm sorry, I guess from the discussion yesterday, I should have been prepared for everything, but it was the fee schedule.
Yeah.
And we did a look around. We did canvass our sister communities in Fairfield County. Planning and zoning wise, the applications that come before this board, we're on par. We're probably in the top 10% or at the top when it costs with the cost per application. Where we are not consistent is with our zoning permit fees, and a lot of communities charge significantly more than what we charge currently. We charge on a $1 per 1,000 of construction costs, and then once you get over the first 250,000, then it goes up to $2. Commercials, it starts at $2 and then goes to $3 when you get over that same value. A lot of municipalities use the same structure, so it's pretty easy to compare. Others use a flat fee for residential, and small non-residential, and then they use escalators based on the square footage. Most they'll use the per thousand or per 2,000, one town does, and then they cap it at a number, whatever that value is. Some stop at 100,000, some stop at 500,000, and then have escalators there. The short of it is we're at that $1 and $2 per thousand number. We're the lowest in the market. We're not as extreme as some other towns. Westport, for example, they have a flat permit fee and then a $2 per thousand square foot. I could show you this. I don't know why I'm talking up.
Well,
Keep
you might
going.
think it's,
We talked about it yesterday. Go ahead.
Okay.
yeah, I mean, and we were supportive yesterday. I
Yeah.
believe that in general, our only concern was don't penalize, don't charge multifamily housing a higher rate than you would anything else. But since it's all based on percent, you wouldn't be, the rate would be the same. And I believe you got support from the commission for raising our fees.
So
Covering
and
our
it's
costs.
it's a combination, right? We talked about raising the sort of base rate, but being sensitive to what I believe Mary was talking about yesterday, and having a graduated scale incorporated into it after the initial threshold, right? Mary can, I'm sure.
Talk for herself. I mean, she's only a lawyer. They can't.
I know. Yeah, I think the idea is that as long as it is applied appropriately, if there's an opportunity to increase it with the size of the project, I think, this is going to be pennies when you get into the multi-million-dollar projects, even single residential. And slightly increased fee is not going to be a problem.
Right.
And I think we also discussed maybe putting some kind of a reasonable flat fee on the zoning verification letters, since that's so time consuming. We're doing it for free.
Yeah.
And nothing, if you do it for free, then nobody takes it seriously.
No, and thank you, Mary. That was my second point. But yeah, so this is our current fee right now as we have it, and these are the gradations of fees for permits. So like was discussed, we have it up to 250,000, over 250,000 for residential, and then for the commercial and multifamily, we have it at 250 and over 250, and then there's a price per thousand. And so, is the recommendation to go up a whole dollar or a half a dollar, or what's the
At least $1.
at least $1?
Yeah.
At least. I mean, if we're still, if we go to $2 and we're still wallowing in the basement of our competitive communities, you jack it up to whatever the mid zone is.
Yeah, I mean, I'm sensitive to going too fast, too quickly, but
Why? We've been too slow, too long.
Well, that's right, exactly.
Not only
you
that,
finished my
but
sentence that it seems that since we've instituted this,
I'm sorry.
yeah, since we've instituted this policy since 2013, we haven't really changed it, and it's probably a time that we're catching up.
Absolutely. 2013. I mean, that's crazy.
Yeah, and then to Mary's point about zoning permit verification letters, it's a mechanism for mostly refinancing or purchases of property. They generally, they're out of town or out of state companies that call, and they ask for a lot of information that we have in the office, but again, it's not something that we have at our fingertips. It requires accumulation, and it takes time, and we don't charge anything for it. Other towns, this is just a small example of what we found, charge 100 to 25, I should say, to $500 for certain requests. I think we were suggesting, or I was suggesting yesterday, $250. I don't know if that's if the commission feels that way, or if they feel we should be charging more for that, but that would be my suggestion, as well as to add that fee, and that would be the only other changes I would ask.
That sounds reasonable to me, Patrick. 250.
I'm good. Well, hold on a second. Arn spoke
Yeah,
up
I'm
for
good.
5.
No,
You
I'm good.
spoke up for
I'm good.
500,
Mayor,
but
I'm
we'll do.
persuaded by Mary.
Yeah, should it be higher than 250? I mean,
Yeah, that was Arn's argument
yeah,
yesterday.
I mean,
Well, I'm backing off. I'm going to
Okay.
go with Mary.
don't
on
back
this.
off. Come on,
No, I mean,
show some back
am
off.
I allowed to be persuaded by intelligent commissioners, or do I just stick with what I said before?
Not if you don't show
I'm
us how to
perfectly willing to say
calculate.
300 if you'd like that, Aaron.
It
300.
sounds
No,
like an
I'm
auction. Do I
fine
hear
with 250.
350?
I know. I
Right
feel
here.
like a yard barker here. Like,
So wait a second. So Arn, what would be the median of those numbers?
oh
God, give me a break.
it's too soon.
I know one person I would not like to calculate it.
Anyway, I will. So, if I could get one motion or two motions.
I'm going to make one. I
Okay.
hereby move approval of the proposed 2025-2026 budget as proposed by the town planner, and also the approval of the proposed fee schedule, including the zoning confirmation.
Zoning verification letter.
Zoning verification letter. Do I have a second?
Second.
Mr.
Well,
Lowe has,
Sorry,
wait.
we're agreeing to 250. I need to say
Yeah,
it here.
250.
Oh, yeah,
Yeah.
zoning
250, done.
verification letter, and that fees shall be comparable. Mr. Lowe has seconded.
Thank you.
Before we vote, I just wanted to say that also, Patrick, if you would do the math up, and based on our current year application volumes, if you would calculate how much incremental revenue we will be generating for the town,
Yes.
that you'd be ready to share that with our friends on the BET that were good doobies. And with that, do you want to just do a voice vote?
Yes.
Yes.
All in favor?
Aye.
Aye. Okay, we got no minutes.
Yeah, I was just checking because if Mr.
We got no
Tell
minutes.
me we walk away without doing the minutes.
It looks like a Trump dance, Madam Chair.
Yeah. A
Uh,
median.
Okay.
Yeah.
The zombie.
I tell you.
Are we done?
We are
Okay.
done.
Bye.
Hey,
Merry
happy
Christmas.
holidays,
Happy
everybody.
holidays,
Have a
everyone.
wonderful
Thank
new
you
year.
for the extra time this month.
And we have a planning session on the 13th of January.
Great. You remind us, won't you?
Bye-bye,
planning on-
everybody.
Bye.
Wait,
Happy New
we
Year,
haven't know
everybody.
anything about the 9th? Oh, well, she's gone. Oh, no, there you are.
7th.
No, I
Our
know about the
meeting-
7th, but we had well, anyway, we have the meeting on the 7th. Well, nothing. We'll talk later about the other thing.
Okay, bye.